Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. We will start our day in Miami-Dade. Undoubtedly, they had a busy weekend there. This is Judge Miguel de la O. Not familiar with him. Let's see what's going on.
Okay, good morning, Mr. Williams. Sir, you've been arrested on one count of aggravated battery on a person of 65 years or older. Would you like to hire a private lawyer or be represented by the public defender?
Public defender.
Right, are you working? If you'll get closer to the mic, are you working?
No, sir, I'm not working.
All right, I'll appoint the public defender to represent you.
So it should be probable cause for a third-degree felony. Also, I have information that the victim wanted to appear in court. I don't know if
Yeah,
they're present.
he wrote a chat that he does not want to stay away order.
Let's see if I can promote him. Hold on. He's under Tony Parker. 1 second. Mr. Williams, are you there?
Yeah, I'm sorry.
Not the alleged victim, Mr. Williams.
Yes. Okay, sir, what's your relationship to Mr. Williams? Mr. Parker? There you go. Good morning, sir.
Good morning, sir.
What's your relationship to Mr. Williams?
No, not Williams. Parker. It's Ja'Cory Parker, not Ja'Cory Williams.
There's two different defendants, Judge. I think we called the wrong one.
Oh, yeah, this is Ja'Cory Williams.
Right.
I can tell by the picture. Okay, sorry, Mr. Parker. We'll get back to you as soon as we call your defendant's case.
Okay, thank you.
Give us a moment. Okay,
You want to handle Mr. Williams, who's before the court?
yes, absolutely.
So again, PC for a third-degree felony.
Okay, finding probable cause. Mr. Williams, Mr. Ja'Cory Williams, do you have somewhere else to live that John Williams doesn't live at?
No, not really. I just have to get a hotel room or something.
Okay, state what's your position on bond?
Your Honor would set a standard bonds.
Yeah, I mean, I was willing to consider pretrial services or house arrest, but if he doesn't have somewhere else to go, that's going to be an issue. And either way, Mr. Williams, even if you post a bond, you cannot go, there's a stay away order from John Williams.
Judge, he does have cousins here in town. He's going to reach out to them to see if he can stay with cousin.
Okay. I assume you have belongings at the house with John Williams?
Yes.
Okay, you'll have permission to go one time to pick up your things, but you'll have to go with a police officer. If you go by yourself, you will be arrested and you'll go back into custody. You're not allowed to have any contact with John Williams directly or indirectly. Don't ask anyone to deliver messages on your behalf. State, I'm looking at his priors. They're all very old. I'm not very old, but they're all over a decade old. Any objection to pretrial services?
1 second, Judge. I'll defer to the court.
Williams one is Parker.
Sorry?
Yeah, it's him first name.
Sign them.
I know why she can't understand that. Go ahead. I'll make a mistake.
I'm sorry, Ms. Zeth, I
I'll
didn't
defer
hear.
to the court. If Your Honor deems it appropriate, no objection.
Okay, I'm going to release Mr. Williams on house arrest. I'm sorry, pretrial services. Alternate bond. You're saying the alternate bonds now are 2,500?
No, so third-degree felonies without force are 2,500. With force, 5,000.
Okay, setting alternate bond at 5,000. Pretrial services, alternate 5,000 with a stay away order. All right, good luck to you, Mr. Williams. Who's this gentleman?
This is Ja'Cory Parker.
Ah,
Yeah.
okay. Now we have the right Jacory on. Okay. All right, so let me first talk to Tony Parker for a moment. Mr. Parker, I saw in the on the chat that you wrote you did not want a stay away order.
Correct.
What is Mr. Parker's relation to you?
He's my grandson.
Okay, and he lives with you?
Yes.
Okay, all right, let me then talk to Mr. Parker, Jacory Parker. Good morning, Mr. Parker. You've been arrested on one count of battery on a person 65 years or older, one count of assault on a law enforcement officer, one count of resisting arrest without violence. Would you like to hire a private lawyer or be represented by the public defender?
Represented by the public defender.
Okay, are you working?
Yes,
What do you do for a living?
iron worker,
Can't hear him.
iron worker,
An iron worker? An iron worker.
Oh, okay, how much money do you make a week?
He's gonna do it, Keith.
probably,
Tony, you gotta tell him now. or else-
it depends on the hours I do, depends how much hours I do, so probably 400 here and there.
Did you say 400?
Mm-hmm.
Okay, I'll appoint a public defender to represent you, sir.
Judge, if I can inquire from the alleged victim, Mr. Parker, how old are you?
Hold on, wait till you're unmuted, Mr. Parker. I muted you because there was a lot of noise in your house. You need to unmute. There you go.
Okay, I would, if with the judge's permission, I'd like to drop all the charges
Sir,
as far
real
as
quick,
I'm
how old-
concerned.
Real quick, sir, how old are you?
I am 82 years old.
Okay. Sir, was somebody just talking to you?
Oh, wow.
Excuse me?
Were you just talking to somebody?
Yeah, my wife just passed by.
Okay. And nobody's forced you to say this?
No.
It's all your choice?
It's all my choice.
So Judge, I will put into the record that the defendant's got priors. He was released from prison in July of 24. I am concerned for the safety of the victim. Also, if you look, he made some threats to the officers as well.
Okay,
Judge,
anything else?
As far as I am concerned, who is his grandfather, not only his grandfather, but I am in charge of the ironworkers local union within which he's employed and registered. As a matter of fact, he's, if you so to release him, he'll go to work tomorrow.
Judge, I would ask if you would consider pretrial services for Mr. Parker.
No, absolutely not. Mr. Parker has quite an extensive criminal history. Does he have somewhere else to stay?
No,
No, Judge.
He's going to need to find somewhere else to stay. I can't let him go home to you just yet, Mr. Parker.
okay, then we will find an alternate place for him to stay.
Okay. I'm
Okay.
going to release him to house arrest level 2. He'll be able to go to work. Alternate bond is going to be 5,000 on count 1, 2,500 on count 2.
That's a misdemeanor, first degree misdemeanor.
Yeah, that's okay. Not all defendants are the same. He's got a
Just want to
very,
make sure you're doing it on purpose.
he's got an extensive criminal history.
I would ask if you would do a standard bond, Judge, 1,000.
Nope. And then house arrest on count 3, alternate bond 1,000. And Mr. Parker, I'm also entering an order, or Jacory Parker, I'm entering an order. You cannot have any contact with Antonio Parker. Since you live at the house, you are allowed to go one time to pick up your things. But you must go with a police officer, and you cannot have any contact with your grandfather directly or indirectly. If you violate this order, you could end up in custody with no bond. So take it seriously, but you will be able to be released on house arrest. You just need to find somewhere else to go live for a while.
Okay, we do have somewhere else for him to go,
Okay,
but I'm gonna have to be in contact with him in order to send him to work tomorrow. That's the only way he can go to work. Because I
So
am the dispatcher.
Yeah, I get that, Mr. Parker. I would suggest you have someone else call him for you.
Okay,
Just so nobody gets into any trouble, including your wife, could, as long as she's delivering the message to him, as opposed to him delivering messages to you,
okay,
that's what's going to get him in trouble. He
Okay.
can receive messages from you.
okay.
Okay? All right. Good
All
luck
right.
to you both.
All right, thank you.
Yep.
Pepto, thank you so much for the $10. I appreciate that more than you know. I really do. You guys support me a lot, and I love it, and I'm really appreciative. Welcome again to the Courtroom Files, everybody. Happy Monday. It's good to have you all here. Lots going on today. All of a sudden, a whole bunch of courts are popping off, so we'll be switching around here shortly to take a look at some other things. I'm just figuring out where to go next. A couple of things to note for today. First, today is co-host Ellie's Gotcha Day. She's officially been with the family for a year. And she's wandering around here somewhere, so I'm sure she'll pop in and say hi at some point. And also, just so you're all aware, I have a hard out at 10 o'clock today. I'm going to do my best to make sure we're not in the middle of some compelling hearing, but if we are, I may have to cut it short because we do have an appointment that we have to keep. So just an FYI. Let's get back to court.
So what's the bond for these?
So standards 5,000. Judge Glazer usually sets 2,500.
I'll set bond at 2,500. All right. Have a good day.
Ashley raises a good point as she counts on her fingers. My hard out of 10 is 10 Pacific, so 1 o'clock Eastern, just so we're all on the same page.
And Your Honor, please review for probable cause, and we can reset the case.
This gentleman there looks like Mr. Carius. I think it's the beard.
Right, and it looks like there are added charges as well.
All right, I'm finding probable cause on Douglas Carius.
But on count one, I don't see that breath was impeded.
Oh, hold on.
It's strangled, right, it does say strangled. And she said she didn't lose consciousness. If you want to find PC or a battery, that's okay, but I think there's enough for PC on the strangulation.
Yeah, no, I'm gonna find PC. Okay, I'm going to set his bonds.
If you're on, just requesting the PC finding, I
Yeah.
don't think counsel's waiving his presence, so we can reset it.
Oh, okay, that's fine. Reset. And it goes with this. Okay, who's the gentleman there?
Your name? Oh, this is the last one on calendar. Alexander Paulino. Stand here, please.
Okay. Morning, Mr. Paulino.
Spanish or English?
You've been charged with battery by a detainee.
Spanish.
A usted lo acusaron de agresión física por un detenido.
You all represent him already, Ms. Corey?
Señorita Corey, ¿ya ustedes representan al señor?
I need to research, Judge, to see if we do.
Tengo que investigar para ver, cerciorarme.
You said yes?
Judge, I see private attorney on one of his cases, James Burton.
Tengo en uno de los casos de un abogado particular, el licenciado James Burton.
Okay, so I'm not appointing the public defender at this time, finding probable cause, setting bond at $2,500.
Entonces no voy a nombrar el abogado de oficio para que lo represente actualmente. La fianza será fijada en un monto de $2,500.
He has a private attorney on one case and looks like public defender on another.
Yes, 2 cases,
Todo
Judge.
indica- Tiene 2 casos. Todo indica
Okay.
que en un caso tiene un abogado particular,
I'll appoint the public defender.
tiene el abogado de oficio. Bueno, pues entonces nombraré al abogado de oficio para que lo represente.
Did I write it?
And it's 2,500 on each of his new cases, Judge?
Correct. 2,500 on each.
Y en cada uno de los casos se le aplicará una fianza de $2,500.
Have a good day.
Que tenga buen día, señor.
So look through here. Oh, you have the calendar, right? Yeah. He might be in the afternoon. Oh, it was an add-on? Philip Sanders?
Judge, this is Mr. Marshall.
Judge, you should have Mr. Rashard Marshall.
He's on page 20, number 56 of the calendar.
Okay, hold on. Okay, Rashad Marshall's. I do have Audrey Roberts down here. I see it now. Okay, Mr. Marshall, you've been charged with battery by a detainee. Just going to appoint a public defender to represent you. Finding probable cause, setting bond at $2,500. But is Philip Sanders going to be one of the resets? Okay. Philip Sanders.
Wardy.
Your Honor, please.
Make up
review-
PC finding?
If Your Honor could review for probable cause.
Okay. All right, I'm finding probable cause on Mr. Sanders. Reset. Okay, Gonzalo Escudero. Corrections, Mr. Escudero.
He refused.
He previously refused. I don't know if the PD waived his presence.
We'll waive his presence.
Okay.
He's in custody on 2 other petty thefts.
Questions? Does he have bonds or programs on the other charges?
He has tap on one of his felonies and 2,500 straight bond on the other.
Thank you.
Any objection to making a tap on all of them? Ms. F?
We're requesting a bond in that the defendant's got multiple theft convictions from this year. The
Yeah.
most recent being a 38-day sentence from March.
All right,
No objection to
finding-
reducing the bond though, Judge.
say that again?
No objection to reducing the bond, maybe 1,000 or 1,500.
Okay, I'll set a bond at 1,000 on all three of his cases. So he'll have a total bond of $3,000.
Which I don't know if you can do that.
You only have one case before you, Judge.
So,
Judge, would you do tap for all of his cases?
okay, but hold on. If I can't set bond at 1,000 on all of his cases, how can I set tap on all of his cases? I think I can address them even if they're not in front of me. We do that all the time in division. No? Am I wrong? Oh, that's a different issue.
It's a clerk issue.
Now that I understand. Okay, I'm sorry. I thought you were just saying I didn't have the jurisdiction to do it and I didn't understand that. Okay, so then I'll set tap on this one, but you're gonna have to, I guess, go to division to get the other cases, the third case.
Okay,
And- Entering a stay away order from Whole Foods, finding
Yes.
probable cause.
No stay away order because he's not here to acknowledge it. So maybe just make a note to get it in division. And tap is over state's objection.
Okay,
Judge, it'll be tap alternate 1,000, correct?
correct. Mr. Reynoso, what case are you here for?
Judge,
Good morning, Your Honor.
On 11.
I'm here on Rodrigo Diaz, Luis Reynoso on his behalf.
Okay, we'll pull it out. We don't have it yet.
Thank you, Judge.
Corrections, can I have Audrey Roberts?
Judge, corrections wants to take the first female out of turn real fast.
Okay. Is that Jacqueline Pacheco?
Yes, she's right here. English?
Okay, good morning, Ms. Pacheco.
Spanish? Spanish? English. She's present, speaks English.
Oh, sorry. Give me one moment. Okay, good morning, Ms. Pacheco.
Morning.
Ma'am, you've been arrested on one count of battery on a medical care provider. Would you like to be represented by the public defender or get a private lawyer?
A public defender?
All right, are you working?
No.
I'll appoint the public defender to represent you.
Judge, her address is listed as unknown. She's got no local priors, but I do see priors out of Central Florida.
Okay. Does she have somewhere to stay locally, Ms. Corey?
Yes, Judge, she does. She's been in here in Miami since October.
Okay. Any objection to pretrial services?
I mean, she hasn't been here a full year for pretrial. Also,
order her
the
in, Judge?
most recent prior, it looks like she did 2 months in jail out of Seminole County last year, requesting a bond.
Okay, what were you saying, Ms. Corey?
Would you consider ordering her into pretrial services?
Yeah.
Thank you.
Okay, I'm going to release her to pretrial services, alternate $2,500 bond.
It is over state's objection.
Understood. 2,500 alternate, but pretrial services. Yep. Oh, Ms. Pacheco, I'm also entering an order. You're to have no contact with Giovanna Figueras, directly or indirectly. I'm assuming that may be one of the doctors.
Can happen today or?
Did we find Mr. Reynoso's defendant? No, he's Mr. Reynoso, who's your client again?
Yes, Your Honor, it's Rodrigo Diaz.
Okay. So corrections, if you can get Mr. Rodrigo Diaz and Audrey Roberts, we'd like to take those out of turn. I have Audrey Roberts, but I don't have Rodrigo Diaz. Eric, somehow I ended up with an extra yellow sheet. Doesn't have any names, so I don't know who it belongs to.
Mr. Roberts, Judge refused.
Okay. He refused to come to court, ma'am. He's been refusing a few times. I mean, I think it's because it's battery on a detainee. I'm guessing he's being held on something else and he's
Yes,
not
Judge.
necessarily going to be released. So sometimes they figure, why come to court? That's all I can tell you. Do you need me to make a PC finding?
I think maybe just at the bond.
We'll waive his presence.
Okay. All right, I'll find PC. I'll set his bond at 2,500. Okay, he won't need to come to court now. I've set a bond for him, but he's got the other matters to take care of first. All right, good luck to you, ma'am. All right, we have Rodrigo Diaz's paperwork, so as soon as we have them, we can take them. But I'll take whoever you have corrections. I think we're going to now go in regular order.
Mr. Diaz? Right here. Stand here, look this way. Judge, we have Mr. Diaz present.
Yeah, good morning, Mr. Diaz.
Hello, how are you?
I'm well, sir. You've been arrested on one count of organized fraud, $20,000 or more, but less than 50,000. Your lawyer is present. Good morning, Mr. Reynoso.
Good morning, Your Honor. For the record, Luis Reynoso on behalf of Mr. Diaz.
Judge, he's got no criminal history, but we are talking about a lot of money.
Yeah. Do you have a PC argument, Mr. Reynoso? Because there appears to be PC.
Your Honor, I don't have the A form unfortunately before me, but I would just like to address the bond amount. There does seem to be a substantial amount with regard to the alleged fraud. If that's the situation, then we obviously like to reserve some of the resources to address that if this were to be filed for purposes of restitution. So we're asking that Your Honor set a standard bond. He's not a risk of flight. He is a partner who he lives with in Miami Beach. He has no prior criminal record. And this is a white collar offense, Your Honor. So he's not a threat to the local community.
Okay. Ms. F?
You want to set a bond? Okay, it's a second-degree felony. Standard bond would be 7,500.
Okay. I'm fighting probable cause. I'll set his bond at 7,500. And Mr. Diaz, I'm also entering an order. You cannot go to the Axel Hotel for any reason. Don't call them. Don't do anything with the Axel Hotel or you'll go back into custody. All right. Good luck to you.
Thank you, Your Honor.
Thank you, Mr. Reynoso.
All right, let's change things up a little bit. Let's go say good morning to Judge Boyd.
So what have you learned from your classes?
Just be patient and handle situations a little bit different. But patience is a lot, especially because I'm on honor. It's been 6 months, so he taught me how to how to keep myself settled and
Okay,
finish things I have to do.
all right. Well, probation, you say he's doing well?
Yes, Judge.
All right, so they say you're doing well. The state is in agreement to the removal of the GPS. Now, once the GPS is removed, don't scream freedom, like Mel Gibson. Don't do that. Make sure you continue to follow through on everything that you need to do and follow through on everything with CPS. You understand?
Oh, CPS is already closed.
Okay,
And also enrolled in school, so I'm trying to stay out of trouble with you.
all right. Let's not try, let's do.
Let's do it.
Let's just follow the rules, okay?
Yes, ma'am.
All right, is there anything else that you need from the court to be successful?
I was just gonna ask when would because I have a no-contact order against the mother of my child.
So you have what?
No contact order.
Mhm.
So I was gonna ask, when can you lift that or
All right, so the first thing with regards to that no contact order, number one, you need to see if there are any other civil orders in place.
Mhm.
And then for me to even consider it, I'm gonna need to speak with the complainant
Okay.
to see if that's what they want. And then I'll confer with the state and see if the state has any objection to it. But I always like to make sure that when I have no contact orders in place, if I remove them, one, that everyone is in agreement to it being removed, and two, that you've learned certain things, okay?
Yeah, because my lawyer said he said he was gonna put a thing to bring it down to no harm order.
Mhm.
And he was like, I think he put paperwork in. like
Alright.
at the beginning of the month, last month, so I don't know.
Okay, I haven't had that. Once your attorney presents it, then the court will consider it. Is there anything else?
Thank you so
Oh,
much.
you're welcome. Drive safely out there.
You have a good rest of your day.
All right,
So
you
I'm good
too.
to go, right?
Yes.
Oh, wait, too. Okay.
Thank you.
Okay, Monday means a good parade in front of Judge West. Let's see how we're dressed today. She's muted again. I hate when she does that. She's that's like 2 days in a row where I've gone to her and she's muted. Let's go back to Miami-Dade while she sorts that out.
Public defender?
Are you working?
No, sir.
I'll appoint the public defender to represent you.
Which I think there's PC. The defendant's got multiple petty theft convictions from last month. Requesting a bond, no objection to maybe reducing the bond on the escape.
Judge, Miss Morgan is not homeless. She lives with her brother and her grandfather. I would ask if you would consider a program,
What kind of program?
either pretrial services or house arrest.
Oh, okay. Sorry. I thought you meant like,
Like a drug program?
yeah. Oh, yeah. House arrest. No, I was absolutely thinking about house arrest. Okay. I'm finding probable cause and releasing Miss Morgan to house arrest level 2. Alternate bond will be $7,500 on count 1, $2,500 on count 2, $500 on count 3. All right, Ms. Morgan, you'll be released to house arrest. I'm also entering an order. You are to stay away from the Walmart on 79th Street. Don't go there or you'll go back into custody and then you won't be released. All right? Good luck to you.
All right, it looks like Judge West got her audio sorted. Let's try again.
With what we're going to do with the case, we're going to respectfully ask the court for a short amount of time, but we'll have on the trial docket or a plea at the next setting. But
Okay.
Given that out, we just need a little more time.
Okay.
It doesn't need to be a 2-month recess, just a month is sufficient.
Oh, well, they're always,
Sorry.
they're typically a month.
Right.
This one might be less than a month
It does.
because this was supposed to be the last, final last one.
But we are close and we've,
Okay. All right, this, I'm gonna reset it 3 weeks. Actually, what week is that? We'll put this on. You guys, where are we? We are here. All right, it's gonna be on the 28th.
thank you.
All right, and y'all need to get whatever worked out. And if there's nothing worked out, then we'll get the rejection done and it'll go to trial.
Thank you, Your
Okay,
Honor.
thank you. Stay in touch with Mr. Morian. He'll let you know when you need to be back and y'all can visit. Make sure you understand what your options are. Okay, thank you.
Your Honor. May I be excused?
Yes, sir. Thank you.
Your Honor.
See, I saw Ms. Norman. Mr. Pageant was here. We lost him. Mr. Price. Good morning, sir. On Dale Johnson, 3 cases.
She's definitely right.
Oh, I just made the noise. I just did it. Thoroughly. Good morning, ma'am. You're Dale Johnson. And Ms. Johnson in 24-1570 is charged with indecency with a child by sexual contact. And in 24-1571 and 1572 charged with aggravated sexual assault of a child. And what is the announcement?
Not ready, Your Honor.
We're waiting, from discovery. I think the judge, I want to remind the court that there was an issue about PISD or some records they were trying to get from BPD. I think we've worked that out. We've supplied all the documents that BPD had, they requested. I'm not sure about, they were looking to get records from Silsby.
I see that.
We have not yet received the records from Silsby that have been subpoenaed. We're continuing to work with those officials in Silsby ISD in our.
Do you feel like they're working on it?
I do feel like they're working on it. I think they're working to understand their obligations in this situation. So.
One thing that we can do, and I think we might have even mentioned this before, if you feel like there's an issue and they're not comfortable responding to a subpoena, just do a motion for those. I can order the production of them, and sometimes that's helpful for them with their obligation if they get a court order instead of a subpoena.
Thank you,
So
Judge.
just don't wait too long to do it. I'll do a normal reset. If you're not getting something the next week or two, and ask them if an order helps, we can get an order done quickly without a court date.
Just I want to make sure that there was BISD, and I think that I spoke to.
We have received the materials from BISD.
Okay.
This is Silsby ISD.
So Silsby's all we're waiting on.
That's it.
Okay, if you'll make a notation of that for me, please. All right, we'll just do a normal reset and let me know if y'all need me to help out with that.
Thank you, Judge.
Stay in touch with Mr. Price to let you know when you need to be back.
Okay, thank you.
Yes, ma'am. Mr. Walker on Adrian Housley.
Judge, can I approach?
Yeah.
If we just sent over the paperwork to him.
Oh, okay. I'll hold it until that's ready. Thank you. Okay, thanks. Yeah. Okay. Okay.
And it's reset for sentencing, so that may be what you were thinking of too, besides Larry Williams.
Yes.
And I put that on.
I think it was actually, now that you say that. Mr. Matuska, do you have something on?
We got something on the initial docket where it had something that had been on the trial docket and it ended up on the designation docket. The bondsman has called and he's late. He's coming from Corpus.
Okay. You were appointed while he was in custody?
Mm-hmm.
Oh, Michael Brasher bonded out.
And then we put it on the designation for,
Okay.
I don't know. But he's supposedly on his way.
Okay. Obviously without a lawyer. We can just let you know how that goes if you want, or if you have other courts, you can come back in a little bit. Okay.
I'll text you.
Okay, thanks. Mr. Gertz, you have David Hatcher. David Hatcher, they'll put on for you. Good morning, sir. You are David Hatcher?
Yes, ma'am.
And in 24-2470, Mr. Hatcher is charged with intoxication assault. And Mr. Gertz, what is the announcement?
Judge, we're still reviewing. This is obviously an intoxication assault case, so it's got multiple component parts. One is the injury to the complainant, and one is the actual scientific basis for the intoxication. We're working on dealing with both of those issues. So we'd ask for a regular resetting.
All right, looks like you have been on since January. I'm going to reset it one more time. I'd really like to see where we can get on that next court date. Stay in touch with Mr. Gertz so that you guys can visit before the next court date. We'll see if we can get an announcement. Any issues, Mr. Nichols? All right, thank you. you're free to go. John Jackson, Mr. Gertz. This was a last
I think,
final.
yeah, we can put it on the
You need to
trial
do it,
docket.
would
I
you
just
do
need
a-
to do a plea rejection. I
Yeah.
haven't discussed it with him, but I just need to do that. I don't even
I'll
know
hold
that
it.
we have an actual plea offer.
If y'all want to get that taken care of, I'll hold it while you do.
Just wants to tell me what it is.
I'll hold it while y'all visit. Go have a seat for a second, sir, please. Mr. Allison, on William Ware.
Yes, sir. Yes, sir. Thank you. How are you?
Good. How about you?
I'm good. I think.
Just a second.
Yes, ma'am.
And sir, you William Ware the third. And will your client waive the formal reading of the indictment?
Yes.
Mr. Ware, in cause number 250257, the state is elected to proceed on the lesser included offense of a Class A misdemeanor, attempted solicitation of prostitution from November 21st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Allison?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
And are you a U.S. citizen?
Yes, I am.
State tenders number 1. It's admitted. Is there any evidence that Mr. Ware is not competent?
He is competent, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings, place you on probation for 2 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have the conviction on your record. And if you successfully complete the probation, at the end, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Did you do your discovery certification, Mr. Allison? Okay. If you will have a seat here in the courtroom, sir, probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over your paperwork. Good luck to you, sir. That's for him.
Okay.
Thank you.
Let's stay in Texas and pop back over to Judge Boyd for a moment.
Actually, I saw the door closed and people still sitting outside, so I was sitting out there waiting. I didn't know that it was already open.
Oh, no, you've been here before and you know court is on the inside. Court is not outside in the hallway. You understand?
Yes, understood. Yeah.
Sometimes I have classes that I have to attend. Believe it or not, judges still have CLE to attend. And sometimes there are other judges who sit for me. And guess what? You'll be going to jail right now if there were another judge on this bench. You understand?
Understood.
Because for them, once they call the docket and once they pass your name and you're not present, it doesn't matter if you come in and they haven't finished calling the docket, they would have the deputy take you in the box and take you all the way to the Bexar County Jail. You understand?
Yes, ma'am.
All right. So today is his plea deadline date.
He wants to set up a trial date.
All right.
Get a trial date from.
All right. How long do y'all expect this trial to last?
I believe no more than 2 days, Judge.
All right. You can have a jury trial or a bench trial. The state, of course, would have to agree to a bench trial, which I'm sure they will. Here's the thing about bench trials. What it means is I hear the evidence, I make a ruling. If the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. So bench trial or jury trial?
I'm going to ask for jury trial.
Jury trial.
All righty. Ms. Ferguson, I need a jury trial date. It's 2 days. Is criminal trial division up this week? Would y'all be available this week?
I believe we have maybe like an 8-case docket tomorrow. I believe we're pretty heavy and set on those cases.
All right, we'll see what happens. We'll put it on the docket tomorrow and see where we are. All right.
Judge, I have a contested sentencing tomorrow in Comal County. On a felony.
And how long is that gonna last?
Comal County, it could last all day. We
that's
hurry up
okay.
and wait in Comal County.
Okay, we'll set it for tomorrow. You'll be here tomorrow at 9 a.m. And then we'll see how long your contested hearing lasts, and we may do jury selection on Wednesday. All right, so you need to be here tomorrow on time at 9 a.m., okay?
Yes, Your Honor.
All right, thank you.
I'm sorry.
If I'm unable to make it, do you want me to?
Oh, just call.
email?
Yes, and then that would probably mean that his trial will be on Wednesday instead of Tuesday.
All right, can I go sit down?
Hmm?
I go sit down.
Yes, and once you
Thank you.
sign the reset form, you'll be excused. And if you all can make sure I have an acknowledgement of discovery.
I can get that right now.
All right, thank you.
Okay.
Thank you. Thank you.
I need to go.
All right, let's head back to Judge West.
Good morning. You are Bethany Loza Diaz. Speak up, please. Yes. And Ms. Diaz is charged with driving while intoxicated with a child under 15. And what is the announcement?
Your Honor, I've been in touch with Mr. Hoffpower, and I have all the discovery and everything. I just received an offer from him, which I believe will take care of the case. I asked for a short reset on her case to get her in this evening.
I wonder, I see this. So I wonder if the reason for this, I'm looking at the email from Johnny's.
Yes, they haven't installed the interlock yet. They're installing it on the 10th. I don't know why.
I know. Hannah, would you make a notation for me to find out? Is that the earliest they could get you in, or is that when you could go?
No, that's when they told me to go. We did get one, they emailed us and told us that was the earliest.
I know, that's gonna be an issue if we can't get, there's other places as well, so we might have to start working on that. That's not, and we're talking a month of no interlock on some of these. Okay, I'm gonna do a normal reset, make sure you get that taken care of on the 10th, and then we'll stay in touch with Mr. Macon. We'll see if we can get your case taken care of at the next court date. All right, you're free to go.
You all have a wonderful day.
Thank you, Mr. Macon. I just want to know from that list, I guess, that there's other options, because their bondsman can give them other options. I don't think they're the only ones that do it. Okay. Okay. Well, that might just be. Miss Norman, you have Edwin Lopez. Good morning. Good morning. Good morning, sir. Are you Edwin Lopez? And in 241908, Mr. Lopez charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Your Honor, we need a reset because we are going to reduce, and I can't reduce it in this court in this way.
Okay.
So, but it will be gone from your court. It'll be a no standard document.
So I'll just do a normal reset. If for some reason that doesn't get taken care of, you'll have to come back. But if it gets taken care of before then we'll get rid of that court date. Stay in touch with Ms. Norman. She'll let you know what you need to do.
Yes, ma'am.
All right, thank you. Did Mr. Paget come back? Mr. Samuel, are you ready to announce on Tyreek Flanagan? Tyreek Flanagan?
He's outside.
We got those, and Kelly's got.
I didn't respond, Your Honor.
I'm sorry?
I didn't get a response.
Barbara, you super chatted while I was chewing. But I wanted to cut in and say thank you so much for the 10. It's very much appreciated. You say, in case you don't know, we all really enjoy your company. Thanks for all you do for us. Thank you. This place does not exist without you guys. Otherwise, I'm just talking to the ether. And that's no fun for anybody, including me. So this is, I said it in the pre-show, this is your space as much as it is mine. You can argue it's more your space than it is mine. So thank you. And again, appreciate you.
2310, Mr. Flanagan's charged with indecency with a child by sexual contact. Are you ready to make an announcement?
We just received the CPS records we've been waiting for.
I mean, Judge, we requested them at the same time, and I went and picked mine up. That was the date on them and everything.
June 18th, they've been ready since
So
then.
I understand Mr. Sam needs to look over them.
All right, I'm going to, reset it for,
You said it one time. So you're gonna do that and we'll talk.
all right.
Okay.
I'll reset it for 2 weeks. Mr. Flanagan, make sure you stay in touch with Mr. Samuel. Y'all can go over this, the last bit of what we were waiting on. This will be the final announcement reset. It'll either be taken care of on that day or a rejection. Thank you.
Thank you.
Mr. Walker on Adrian Housley. And have you got your discovery certifications? Y'all got it, okay.
I just need to email the.
It's fine. Good morning, sir. Are you Adrian Housley?
Yes, ma'am.
And Mr. Walker, will your client waive the formal reading of the indictment?
Yes, ma'am.
And we're going on, let's see, let me get this pulled up right away. The whole indictment.
Yes, sir. With all the problems.
All right, excuse me, Mr. Housley, in cause number 250290, you're charged with the state jail felony offense of theft with previous convictions, and that's from November 24th of 2024. The indictment alleges you were previously convicted of theft December 20th of 1989 in 3 cases, and then June 15th of 1992 and June 25th of 1992. The indictment further alleges that you were convicted of burglary of a habitation, a first-degree felony, June 15th of 1992. And after that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 5th of 2006. And then after that was final, you were convicted of possession of controlled substance, a third-degree felony, October 4th of 2010. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Walker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, it looks like the agreement that you've reached is for a cap of 10 years in prison. Is that correct?
Yes, ma'am.
And what that means is that you're leaving your punishment up to me. And as long as I don't give you more than 10 years in prison, you're waiving your right to appeal. I can give you 10 years, I can give you less. It'll all depend on the information that I receive when we come back for sentencing.
Yes, ma'am.
You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Housley's not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm not going to do that today. I'm going to reset your case for sentencing, and we'll get a pre-sentence report done. Anything that you think is important for me to know, get that information to Mr. Walker, and he will present it to me on your behalf when we come back. When you're leaving the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there, and she'll tell you what you need to do. All right? See you back at sentencing. Thank you.
We're hopping around Texas a little bit today. Sometimes it just works out like that. Let's go back to Judge Boyd.
Morning, Judge.
Good morning. How are you doing today?
I'm doing okay. How about yourself?
I can't complain. Currently alive.
Yeah, it's true.
Good.
We're dry and yeah,
Yeah.
much better than the alternatives.
I'm at the age now where I realize, oh my gosh, I'm gonna have to start doing stretches. Because I'm like, my back was hurting a little bit. And then I said, oh, I need to do stretches. So now that I've started with my stretches every morning, everything's fine.
That's good.
All right. So last time we were here, there's some missing photos, body worn camera, forensic interview of the witness. So
Yes, Judge. And for an update on it, we were able to get clarification on the photographs. We were able to get the body worn camera videos. We do have the forensic interview of the child.
okay, so just 1 second. Let's take it one step at a
Oh,
time.
of course.
Yeah. So forensic interview, you have that?
Yes, ma'am.
All right. And counsel, you just need to confer with the state on that.
We did talk on this past Thursday and went over some of the evidence. I had not watched, I represented to him what was in the forensic interview. We haven't shown it to defense yet, but we do have it. So.
Okay. And then the body camera?
Yes, that is downloaded into Veripic.
Okay. And then the photos?
The photos, there was some differences where the report said a certain number and then we received a different number. I did clarify with the detective, the report just had the wrong number. So the photos are all included and they have been included. We just needed that clarification.
All right. Is there anything else?
There is, yes. The 911 recording, this originally went to the city on the 911 call. It later got transferred to the sheriff's office. So I did contact Detective Solis, I guess at the last hearing, to try to get that recording. He has requested it from SAPD. We have yet to receive it yet from SAPD,
All right.
however.
When do you think you will receive it?
Judge, typically it takes around 2-ish weeks. So I would have thought we'd get it soon. I mean, my hope we'd get it within the next week or two.
I mean, don't they just like upload it in the system?
They usually do when it's their own case because it was another agency. I think that's where the hiccup happened. Because if it was sheriff's office, they would have done it immediately. But because it was another agency and they didn't have that JN number, I think that's where the confusion happened.
All right. Other than the 911 recording, is there anything else?
No, not to the state's knowledge, no.
All right. Do you think there's anything else, counsel?
Well, other than being able to see the interview or the
forensic interview
and the 911, that's all I'm aware of now.
All righty. Ms. Ferguson, on this one, let's do a 20-day reset. And at that time, state you'll need to be prepared to tender an offer.
Oh, of course. And for the court's knowledge, I did inquire with the detective on Thursday about the status of the 911. He was still awaiting it. So.
Okay.
But I'll check again later this week.
All right. Thank you. All right. July 24th. An offer will be due. And if there's some other discovery missing, then what's going to end up happening is this next date, witnesses need to be subpoenaed to be here to see why the discovery is not here.
And, Your Honor, I'm actually out the week of July 21st.
Okay.
Would it be possible to have it on the 28th, the Monday?
Norma, put this on July 28th. Defense counsel is out.
Or status.
I'm sorry, state is out.
Thank you, Judge. I appreciate it.
Welcome. All right. Is that good for you, the 28th?
Yeah, that's fine. 28th.
All right. So we're going to bring you back on the 28th. What's going to end up happening on that date? They're going to make sure that they have all their discovery and the state is going to tender an offer to you. And then once the offer is tendered, I'm going to reset it for your plea deadline date. And if an agreement is not reached at the plea deadline date, then what will end up happening, you'll be set for jury trial. You understand?
Yes, sir.
All right, do you have any questions about anything? All right, thank you.
Thank you.
Thank you, Judge.
You're welcome.
Yes.
All right, let's change it up a little bit. I'm going to take you to Louisiana in the Wayback Machine just a little bit. This is a hearing that has happened this morning, and I've been keeping an eye on it. It's a little bit different from what we normally see in Louisiana. This is a pardon hearing, and the gentleman who is petitioning for the pardon has already served his time, and he's out in the community. So something a little different. It does go on for a little bit, but I think it's worth it. Let's give it a look.
Dickens, would you introduce yourself? Tell us your name and your current mailing address.
Name is Tom Dickens, out 48 Hannah Street.
And counsel, would you introduce yourself? Good morning.
Katrina Jackson, address is 4160 Street, Middleton.
Thank you. And let me acknowledge, before we get started, we're going to acknowledge the folks who are here in support. On Zoom, we have former Sheriff Jay Russell. We also have Christian Creed and Mayor Gerald Brown. We have some family members here with us in Baton Rouge, Allison Johnson Dickens, Anlin Duvall, and Ariana Duvall. And thank y'all for being here today. We appreciate it. So, Ms. Jackson and Mr. Dickens, your case has been assigned to Mr. Tillis, but before I turn it over to him, we'd like to hear from you all. First, Mr. Dickens, tell us why you applied for this and why you think we should vote for you. And then we'll hear from the folks that want to speak on your behalf, and then we'll hear from your lawyer. Close it up, and then Mr. Tillis will start beginning. So go ahead, sir.
This, I feel like, I went really clear wrong.
Let me, sir, while you collect yourself, I'm sorry, I was supposed to read that into the record. I have not done so. So let me just do that and just take your time to catch your breath. Your DOC number is 288851. You're seeking a pardon with restoration of firearms. You were, your parish of conviction is the 4th Judicial District, Ouachita Parish. And the record, let's see, there's 1990 assisting escape. You received a 3-year suspended sentence, were placed on 4 years probation. 1992, 3 counts distribution of Schedule II cocaine. You received 10 years on each count. Those were to run concurrently. 2009, distribution of methamphetamines. You received a 25-year sentence, but all but 7 years were suspended. Then there's a 2004 violation of protected order and domestic abuse battery. You received a 7-year sentence on the protective order violation, and domestic abuse was 6 months parish jail, and that was suspended. You were placed on probation. Is that information correct, sir?
Yes, ma'am.
Okay. Now go ahead and tell us why you've applied and why you think we should vote.
Like that, like that, like bad choices, and I ain't wrong with people, but, and I always pray this to God, if I ever got the opportunity, that I always show a lot of young people that this is the right way to go, and that's what I do. And but not knowing that I was going to be coming at this point, and not knowing I just took 1,000,000 pictures and showed you all, but I was doing it from my heart because I was letting them know, hey, you don't want to go down there. They're not going to play with you down there, and I did wrong. And then I say now, I used to run from the law. Now I used to go talk to the police officer. I ain't got to run when I see him. I can talk to my helper. I don't. When the incident happened, they call me and say, "Hey, y'all stop. We don't need to do this shit." And so I feel good about coming to your home and say, give me an opportunity because it's hindering me from trying to do different things that I'm trying to do more in life to show the young people you can change your life from the areas that I come in. Everybody make mistakes. You can change. And that's been 20-some years. And you all ask God to give me the opportunity to move forward in life.
Thank you, sir. We'll get a little more into that when Mr. Tillis starts his interview. But we'll hear first from the folks that want to speak on your behalf. Could we hear from Mr. Russell, Sheriff Russell? Is he on? right. Well, he's trying to get in. Let's see, is Christian Creed. Did we hear from Mr. Creed?
Yes, ma'am. Good morning, Madam Chairman and members of the board. In the interest of time and brevity, I've prepared a written statement that I'll read at this time. Again, my name is Christian Creed. I'm a practicing attorney and member of the Louisiana Board of Regents. I'm honored to speak today on behalf of Tyrone Dickens, a man whose life exemplifies true redemption, profound rehabilitation, and an unwavering commitment to community service. Tyrone's past includes very serious mistakes, but over the past 20 years, he has transformed his life entirely. He's generally contrite for his past offenses and has dedicated himself to making a positive impact on others. His acts of service are numerous and heartfelt, from distributing waters and fans to the elderly and impoverished during the summer heat, to collecting toys and providing holiday meals to families in need, and assisting families during emergencies, catastrophes, and natural disasters. These are just a few of the things that Tyrone does on a regular basis every year. He also regularly helps stranded motorists, feeds children in housing projects, and gathers school supplies each year to support students starting school. And most importantly, and I believe he touched on it, Tyrone mentors children across elementary, middle, and high schools, sharing his personal story of turning away from a life of crime to one rooted in service, education, and family. He works collaboratively with law enforcement, not as an adversary, but as a partner, helping diffuse tensions, and in many cases, saving lives through his proactive involvement. And I know Sheriff Russell's here to talk, and he'll be able to touch on that as well. His story is one of genuine transformation. He's not been in trouble for over 2 decades. He abstains from alcohol and drugs, and he conducts himself with integrity, free from profanity and vices. Like, he gets on me if I happen to say a bad word. So that's Tyrone. Today I speak on a man who's earned a new beginning, one rooted in service, humility, and responsibility. A pardon would acknowledge his complete turnaround and enable him to continue his positive contributions to society. I respectfully ask the board to consider his remorse, his ongoing dedication to the community, and his exemplary character in making a favorable decision today on Tyrone's behalf. Thank you very much for your time and consideration.
Thank you, sir. We appreciate hearing from you.
Yes, ma'am.
Mayor Brown, do we hear from you, sir?
Absolutely. Good morning to you.
Morning.
First of all, I want to echo all of the comments that Mr. Creed has stated. It's difficult for me to add to that. I want to kind of come at Tyrone from a little bit different perspective, though. He and I met just about 10 years ago when I was preparing to run for mayor. I had heard of him, but didn't know him. And I think he had kind of the same relationship with me. And so before I got ready to run, we had breakfast one morning, which turned into brunch. We ended up talking so long about our community and things that we would like to see happen and things we wanted to do, and frankly about his past. My father, Warren Brown, is a 40-year law enforcement representative in Ouachita Parish. He worked for Monroe PD for 29 years and then for the district attorney's office for another 15 years after that. And so the joke that Tyrone and I had when we had that breakfast meeting was that my father had arrested him multiple times, some 20 plus years prior. And so my dad is one of my greatest sounding boards. And so I went to him after that meeting and I asked him about his relationship with Mr. Dickens and some of the things that, perhaps had happened. And we talked frankly about those. And I told him that some of the things that Tyrone was doing to try to change his life and turn his life around. And my dad, who was at the time was 76 years old, said he'd like to sit down and have a personal conversation with him about the changes in his life and potentially, me starting to have some dealings with him. And so he came by the house. My dad and I actually lived next door to each other. So he came by the house and we talked. again for probably a couple of hours. And my father was kind of overwhelmed by some of the things that Tyrone has done and tries to do in our community, and the way that he's changed his life around from his previous dealings with him some 20 plus years previous. So the thing that I like to iterate about Tyrone, and look, with the town of Richwood, he's been a tremendous community partner. We have done everything from back to school to COVID to senior citizens to feeding kids at school. We've done all kinds of things. But the thing that impresses me and that I try to impress upon people, especially some of our younger people, is that there's the ability to turn your arc around if you really want to. Tyrone has demonstrated that. He's worked hard to fix his reputation. He's worked hard to be stalwart in our community. Oftentimes, when there are issues between certain folks, Tyrone is one of those people that I like to get involved in those conversations, because he's a person that people will listen to based on some of the things that have happened in his past, and some of the things that's happening now with him in the present. Um, uh, I wasn't as smooth as Christian and do a written statement this morning, because I felt like if I wrote everything down, I might shed a tear. So I didn't want to do that in front of you. But he's been a tremendous community partner for the town of Richwood. My event staff have him at the top of our list when we start calling people about needing resources and figuring out how we're going to put things together to do things for seniors and children and unemployed and underemployed in our community. He's always right there to lend assistance to us, and we certainly would appreciate any consideration that this board would give to him today.
All right, thank you, sir. Thank you. And I see Sheriff Russell. Good morning, sir. We'd like to hear from you.
Good morning. Want to thank the board for allowing me to speak on Tyrone's behalf. The main thing I want to say about Tyrone is that he gave us the opportunity many times in law enforcement to work together. One such instance was we had a barricaded suspect at a house. We were fixing to have to go in and get him. He was armed. He had several felony warrants on him. He began to act irrationally, and my negotiator said it's not going very well. Tyrone called me, and he had a rapport with the suspect inside, and he told me that if I would allow him to speak to him, he could probably end the situation without anyone getting hurt or anyone having to go in and get him, which we didn't really want to do. But it was sort of unorthodox, but I did, and I called my negotiator, and he put him on the phone, and they connected with each other. And about 15 minutes later, the man gave up, walked out, gave up his weapons, and we didn't have to go in. Several times after this, Tyrone and I worked together on several projects within his community. I agree 100% that a man should have to pay his debt to society, which he did. But I also believe that a man has to prove to his community and society that he's a better person, that he can make people around him better, and that he can improve the quality of life of those in his neighborhood. Tyrone's done that, and he's shown that time and time again. My relationship with Tyrone was always about the law enforcement side of things. But I also saw him speak on several occasions about upbringing and children in his neighborhood and the positive influence that not only he could give and not only the people there, but law enforcement could give. And I appreciated that part of it too, because he understood without law enforcement and good quality law enforcement, societies can't exist. And he's shown that time and time again. So on his behalf today, this is the first time I've ever done this, to be honest with you. I usually are speaking on the other side, trying to keep people incarcerated. But today I thought it was important to do this because he talks the talk, but he also walks the walk. And he's done that time and time again. And I appreciate him as far as me, when I served as sheriff, he helped us out several times. And if it didn't work out, at least he tried. And like I said, I agree with the mayor and Christian on both accounts that he has shown time and time again he does care about his community, and he's working toward making it a better place. And I appreciate the board's consideration in this matter today. Thank you.
All right, thank you for speaking with us today. We appreciate it. Thank you, sir.
Thank you.
Ms. Jackson, I'd like to hear from you.
Of course, I am representing Tyrone, not like an engaged attorney, but as a pro bono attorney. Because as others have stated today, Tyrone in 20 years has done more for the community than most elected officials. He has become the go-to person when you're having a difficult situation in school. Principals call when the principal sees something in a child that they know something's happening at home, but it's making the child act out in school. They will call them Tyrone. Sometimes the reason why I know is sometimes when they can't get them and they don't know his number, they say, "You know, Tyrone, you get them a call." Also, in parts of the city, even though we're a small city, if you know anything about Monroe, we didn't really experience an influx of crime pre-COVID, but especially during COVID. We have somewhat, unfortunately, in a small town, a gang situation, east side, west side, even those 5 miles, it makes no sense to me, right? So when you cannot engage in certain public housing, apartment complexes and facilities, a lot of us take Tyrone, whether it be law enforcement, myself, in times of emergency, because we're trying to defuse the situation. But Tyrone in his 20 years has built relationships, not with people like us, but more with people in the community of children who have been maybe been brought up by him, who he sees going on the road path. He also goes out with pastors a number of times. And this just didn't start. This has been a 20-year period, right? He has generally made our community, not for the people who may have access to everything, us too, because it keeps us safe, but for the people who, the children who do not have access to everything, everything. And if he sees a situation, you don't have to call. Usually he's calling, someone who needs resources, needs help, and say, hey, just recently, part of the apartments, one of our largest public housing complexes in Tricia, lights were out. We experienced, we go about in South Louisiana, we experienced a storm. And they didn't have food. Every day consistently for 3 or 4 days, Tyrone would text and call someone and say, if you help me, I'll take your food. If you help me, I'll take your food. That's just simply who he has been. But in doing that, he's developed a pathway to talk to children in need and who are going down the wrong path. The juvenile gets arrested, generally, if it's a serious situation, sometimes the first person will call the community to talk to him is Tyrone. Look, I know the offenses are what they are. I've looked at the record, I helped submit the application. But a man's total sum in his life cannot be equated even in 10 or 20 years back, right? Because who we are at 20 and 30 are not who we are today. I love to say I'm 30, but I'm not. And so who we are at 20 and 30 years old is not who we are today. I make no light of anything that occurred in his life, but I do make a big impact statement on what he's done in the community. And why I'm standing here today. I will not, you don't see me before you all. For the very reason of, sometimes with victims, it becomes a conflict of interest. I spoke to victims. I've worked with alleged victims and all of that regarding Tyrone, and all of them have worked with him since in the community, engaging in what we feel to be something that benefit what we see. When COVID, I was sick. I had COVID. And everything was shut down. We had ice on. And no one could get water in or out. I called 2 people. I couldn't leave my house. I called Pastor Riley and I called Tyrone Dick. And I said, tomorrow you should be able to get through the water. Because when it iced over in my poor regions of the area, they didn't have running water. I said, if you do have a warehouse of water, can you please get there? I said, I'm getting too many calls that people don't have running water. They don't have a way to get out of my rural areas. That next morning, 6:30 call was Tyrone saying the roads are clear for me to get through. With a trailer and a truck with the people. I can talk about numerous stories because Tyrone is not a crime. He's become family. In Texas, the Lord, I hate to say it, they're experiencing flooding. But when Houston, Texas was experiencing their flood, my sisters and my cousins were in Haiti. My mother was freaking out when she called me. She said, "Who can you call?" I said, "Only person I know with a truck that was driving that fork bus and was driving on the drop down that people is Tyrone." I was on pins and needles the whole trip because my mom was with me. But he brought me home safe. And if you talk with people in the community, Tyrone has been a go-to in times of disaster, in times when children or even adults, like the sheriff said, is on the wrong track. I just plead that this is not all about Tyrone, and I understand that there are businesses he's going to go in, like he wanted to do notary, he wanted to do inspection things. And we couldn't help them fill those applications because of his record, he was part. But what I do know, and this is just, I can say a whole lot, Tyrone's not a person in the community, he's family to all of us. Attorney Christian Creed practices civil law. He become family to him. Everyone would have been here today, but somehow with a mix up with the mail, we were having trouble. I tried to tell everyone to certify mail mean anything. We didn't receive the April 11th, but your wonderful staff called on Thursday, day before 4th of July, and confirmed his hearing. So I want to applaud your staff because they follow up. We found out Thursday. I counseled everything I could, but everyone on the screen would have been here if they could. We found out the day before the 4th of July about this. And we're here, and if anything happened on Zoom, from the calls and texts I was getting this morning at my office, and my office texting me, people trying to get in. We see a community of people. But this is not just about Taiwan. It will benefit. There's no doubt. But this is about the community back home. Who's ever who's wondering if people can have a second chance. These are for the young man and the older men who are just coming out of something which I want to tell. Who just told them that if you do the right thing, when you're out of trouble, if you turn your life around, you can have a second chance. There's so many people in the community, as I was driving last night, that was texting, saying, "How do you think it's gonna go?" And that's why I say it's for the community. It shows them that what he's told them so long is true. That when you turn your life around, when you begin to engage farmers, when you begin community service, when you do all you can for a community, there's a chance for redemption. And that's really why I say, probably not standing here as attorney more than just as family, as someone who respects him, who's seen what he does for people. And honestly, no defense attorney, Tyrone has turned more of my clients' life away than I could ever have done sitting in front of him. I have 2 other attorneys in my office, even though we're separate, and most of the time, if we see a kid that comes through our office, we'll help them to a vulnerable if we can. But then we send them to Tyrone. We take Tyrone and need to be considered. I don't want to see him go there for. And he doesn't just sit with him that day in the office. He follows up with him. He takes pieces to exclude the piece points. He follows up with that child to make sure that teenager never sees jail with him. And so for that reason and more, I ask you, and this one would have been full had it known before Thursday. So we were all geared up to come.
I'm glad you're here. Thank you. Thank you for that presentation.
And I would like to see his wife is here, Allison, who used to be my legal assistant in my law office, who is now, and that was after I met Tara, who is now working with autistic kids. She has autistic, they have autistic child herself. She's working at the school with autistic children. Their daughter, who's in field right now, finishing up next year, and their daughter who is going to be a junior, I believe, at Washington High School.
Well, thank you. We're glad y'all are here. So, Mr. Dickens, I'm going to turn it over to Mr. Tillis. Would you answer his question?
Good morning, Mr. Dickerson. I started reading your case. At the beginning, I said, well, they're gonna bring him in cuffs. I'm a bad guy. But how long have you been out in prison?
Since 2007.
2007?
Yes, sir.
Okay. You got some big guns with you. I have no more questions.
Any other question?
Yeah, I mean, one of the things, we know that you had the drug problem, that possession with distributing. And also at one point when that happened, you were in possession of a firearm by a convicted felon. Also, that's what it says here in the breakdown. Was that true or no? Did you have a gun?
No, ma'am.
You didn't?
No, ma'am.
It was just the possession of drugs. That
Yes,
was right.
ma'am. Yes, ma'am.
All right, so let me ask you about this one. In 2004, they responded to a domestic violence incident. I don't know that she was your wife. Was she your wife?
No, ma'am.
She, okay, but y'all had children together.
Yeah, yes, ma'am.
So it states here that when you arrived, it was about a birthday party for a young child that was yours. And that there was an argument over child support. And then it got worse because at that point she said that you began choking her around the neck and that you said you might as well go ahead and kill her. And you got her down on the ground, on the floor, and you were kicking her. And when the police arrived, she said that you had a knife and you were going to stab her, and they saw a small cut on her arm. What about that incident? And she already had a uniform protective order in place at the time that happened.
Yes, ma'am. I can recall correctly on that, I just said, when that was like 2000, just, tell you the story before spring, I had my son, and when she grabbed me, I grabbed my son around. And when that grabbed me, and I pulled my son, so they said that I ended up grabbing her with him, and considers me trying to strangle, I was shaking, trying to get straight like this, very cracks.
You didn't put your hands around her neck?
Yes, ma'am. Once I did, because when I did, I did her grab me. Yes, ma'am. He
You
said,
said she was holding the child.
yes, ma'am. I ain't trying to grab her. It was her, though. We just said it's straight. Yeah, but not grabbing her. I'm showing you how I did. I grabbed her.
So that's why you had a domestic abuse
Yes, ma'am.
count, but it was in the presence of children also.
One child.
One child.
We've been dealing with each other. She's been working with me on community events since.
That's what I was gonna ask you. What's your relationship with that victim?
With we pray. Now, I thought you just wish me luck. We talked. She told me we got reached out to her, whatever. She told so everybody deserves a chance, and we said my kids are grown. And I'm still being a parent to them. Actually, just exactly talking. Tell me on the lane, checking me and told me, "Good luck, Dad. You got this." We got a great relationship.
So the children and you have a close relationship.
Yes, ma'am. Definitely. Yes, ma'am.
Okay, that's what I wanted to know, because that was pretty violent. That
Yes,
thing.
I was young too. I told her, apologize, I did.
Okay, that was my question.
Yes, ma'am.
Any other questions?
I know they have a good relationship because at some point we've all donated to something and helped them out. Something. That's one thing about this party that's so very important. It limits your ability when you don't have a party. You go in certain fields to make a living. Tyrone has, you guys have 4 kids. Right? 5 kids. 10 is wife together. And he has the kids you're referencing within another child. And he tries his best. And I know this person to do everything he's doing.
You know, I forgot to ask the question, with all this community work, that's takes a lot of time. What do you do for a living?
Well, deal with them. I mean, take people to Green Oaks and the ground and mental detention home. And
Are you paid for that?
no, ma'am. They are the court system.
Oh, you get, okay. You get
And I get disability.
disability.
Yes,
Okay.
I go down there volunteer, and recently, I mean, they told me I got bit by a snake trying to grab a young lady out of the area that was flooded, and let's say it was bad neighborhood, got bit, still grabbed off the dress that she was carrying a child. The snake got one around it, so they didn't process that. Son got in trouble recently, and they called me, said, "Call me." And I took him to detention home and said, "Look, I'm not scared you straight. This is what happened. Ask me. This ain't what you do."
And that's why I keep referring to business ownership. Tyrone's disability and his needs and everything does not allow him to consistently sit or stand for a certain amount of time. so he's on disability. It's my belief, his wife's, that at some point, if he can't get a business that the family can work in, that will give him income besides social security disability.
Thank you for answering that. I appreciate it.
Yes, ma'am. Yeah, I want to speak on one of them. I hear. Yeah. But if you go over, you see, if you put your hand on a woman, I talk about that on the domestic violence. That's a weak individual. Because Lord knows I have daughters. I would never want nobody to put their hand on my daughter. So, and that's why, you know, they tell me all the time, my kid, I did tell you, I'm sorry. I can't do that. I tell my kid, you know, don't do that.
That's very important. And you are doing a wonderful job. And you really are. That's very,
But like, I'm ready to go to Dillon University.
yeah,
I mean,
that's wonderful.
yes. And dealing with 2 girls, man, that's a struggle.
Everybody says that in order to deal with boys. I know, I got 2 boys, so, you know, that passed me, but my neighbor had 3 girls. It is different. Okay, thank you so much for answering my questions. Mr. Prater?
I was looking at I do some research on these cases, and I was looking at the internet. Do they call you K9?
Yes, sir. Let me tell you that story. It's because when I was in prison, the 2 guys got to fight. And one of them juked me.
Okay.
And when he juked me, I needed to grab both of them, holding him and holding the knife, that hit him in the head also. And when I got out and going to DD court, the man asked me, why did you start that fight? I said, man, I don't want to see them 2 killing each other. And from that point on, I never forget his name was Warren Good. He told me, man, you know what, you're a lawyer to do. He said, ain't no way I did that. He said, you remind me of my German Shepherd that I have. He said, that's the most loyal thing I ever seen in life, to protect somebody else and get them out there, use them to hunt mines and all this type of stuff. Ever since then, they didn't call me. I did.
Reason I was asking, I saw one article in there about a liquor license.
Yes, sir.
Did you have a liquor license in 2017?
No, sir, I was applying to help the daiquiri store.
I'm sorry?
I was applying to help the daiquiri stores.
Okay.
They say you have to come to get a liquor license in order to be able to serve alcohol. And I never knew it, so I just applied. Then I went back to a class, and you know, so now they said, well, you have to be, you convicted felony. You cannot get it. I was like, oh, I didn't know that. And I told, like I said, I didn't have millions and millions of pictures if I knew I was being prepared for this type of stuff, but I did it from my heart. I wouldn't never expect I'd be sitting in front of you all. I used to run from the laws.
Right. Well, I was just reading that article, and it said something about liquor license had been revoked because of violence.
Sir, they wouldn't give it to me because I called it a violent previous of me being on, parole and all that type of stuff. And I was in jail. They said because we've been a convicted felon.
Well, the article just says that you had a liquor. It said that it was making the comparison that the city council gave you an award for your work in violence, preventing violence. And at the same time, they revoked your liquor license because of violence outside your place.
No, okay, there you go. I know we on there. That was the deal I was running, selling water and ice called Club Nouveau. It belongs to Mr. Mojo. They wanted a BYOB. And the city was telling me that they had to take that BYOB because at the time I was the one running trying to sell liquor and it was a BYOB, not a liquor license.
He was managing someone else's
Spot,
spot.
yeah.
Mr. Mojo is a business owner. He owns gas stations and some other things. That was a way of him making income. But because he had a violent past, they revoked Mr. Mojo's, I believe it was, liquor license because of Mr. Dixon's tax.
Okay.
Because he hired him.
Right. And finally, tell me about I see you were arrested for a rape charge. but then it was dismissed.
Yes,
Is that correct? Tell me about that, because we even have to consider things that are dismissed, you know, not saying you're guilty of it, but I kind of like know the circumstances around it.
we was together, we was going together, and we gonna argue, and both sitting there kissing, and this thing, we had a little small argument, and then her mom came over and called the police, and she was sitting there, and so the police said, well, did you do it? Then she said, well, I was telling you that, but I did, but for it to be taken off, so. We was together, and we was together after that, and then she went and told the police, she told her lie, her mom and forced her to do it, that's why they dismissed the charge, but she said that her mom told her to do that, because I told her I couldn't be with her no more. If you look at it, no disrespect to you, if you look at the year when it was the same young lady, I had kids by.
And finally, why do you want a gun?
Why do I want a gun? Ain't that I necessarily want a gun, but I want to try to take my kids hunting. My son been talking about hunting. And of course, a lot of people I be around, I don't know how to hunt, but I'm willing to learn. But my son always wanted to say, let's go hunt, Dad, let's go hunt. Because when my son go to a school, which is Beach Watchdog, they always showing pictures of deers. And I'm like, wow. And they got little homing things on the head on the wall. And like, Daddy, can we go?
It's a very rural middle school, but beautiful. My nephew went there.
And I was like, oh. And I was like, what is it? And I said, it's a 6 gold, 7 gold, whatever points or something. And I was like, oh, okay then, but I never knew nothing about it.
And if I may share, Mr. Dickens walks a lot of us as community leaders into a lot of dangerous places. So I'm going to speak on that point of gun restoration, right? Because they trust him in the community sometimes, and thank God they trust me. I'm still a woman. And he walks a lot of us into very dangerous places. And he rescues a lot of people in time of emergency out of very dangerous places. And so that would be my concern. And that's why when we filed the application from my standpoint, that I requested conversation with him with restoration guns. I bought my first gun 3 years ago. It's pinky green. But I bought it because of increasing, honestly, situations, driving. And I got stopped in Mississippi, not because my car was ragged, it's because I ran out of gas. It's a running joke that I don't use the gas in. And I didn't have it then. I did not have anything. And I sat on the Mississippi road for an hour and a half. I don't usually do it. And I only say that not to make light of it, but to say Tyrone does that a lot for a number of community people, even transporting our children and, things like that.
That's all I know.
Okay, thank you. Just let me advise that, we reach out to the community, and there is some opposition, particularly by the district attorney. Mr. Chu says, subject is a 6-time felon, including one from Texas. He should receive no part. Later, he in no way needs to receive, especially his gun rights. So you need to just be aware of that. I don't see any other questions from my colleagues. Are you ready to vote? Can we go into executive session, please? We have a motion by Mrs. Stapleton for executive session. Is there a second? Second by Mr. Prater. Can you call the roll, please? Yes.
Yeah.
Here, yeah.
Here.
Yeah.
Yes.
All right. We're going to be in executive session for just a few moments to discuss confidential matters. We'll be right back.
Okay, well, they go into executive session. The good news is we're in the Wayback Machine, so I can fast forward past that. But while I do that, this is the hallway in Clayton County, Georgia. Some stuff went down over the weekend. Just take a look at how packed that hallway is. This is all first appearance. So that, dear friends, is how many people got arrested over the weekend in Clayton County. Ashley will probably shake her head and go, yeah, that's about right. But, yeah. Give me just a moment here. All right, let's go back to the hearing.
We're back in regular session and we're ready to vote. Mr. Dickens and Mr. Prater will be voting first.
Okay. Mr. Dickens, I appreciate all the work that you've done, and I applaud you for being remorseful for what you've done and the connections you have with your kids and your family and everything you've done since then. And my vote is that you received the pardon, but I can't in good conscience go with the firearms. So my vote at this time and recommendation to the governor would that you receive a pardon for all the charges, but that you not have the right to carry a firearm. That's my vote.
Okay, thank you, Mr. Freeman.
My vote is gonna be the same. I'm not gonna lie to you. I came in here with a definite no, but, your support is great. Things you're doing for your community is obviously just unbelievable. So my vote will also be to grant. My recommendation to the governor would be to grant, but I also would be without bond.
Mr. Tillis.
Mr. Dickens, I commend you for the service that you've done in the community. Your friends speak very highly of you, and my vote today is to grant without firearms.
Mr. Dickens, I'm like the rest, that the community service and your support is outstanding. There's no doubt about that. But the domestic violence battery was very violent. And then the drug charges was in 2006 was extensive also. But I do agree that since that time, you've done a lot. And for you saying, I didn't hear from Ms. Dorsey and the children, but that you have a relationship with them, a close relationship. So that's been mended from the event that happened in 2004. Based upon that, I agree with my colleagues, Mr. Tillis and Mr. Freeman, and Mr. Prater. I'm going to vote possession without violence, so because of the violence.
All right, Mr. Dickens, and I agree with everything that's been said. I'm impressed by the work that you've done. You do live a life of service now, and thank you for helping the community. Some of those the same as my colleagues, pardon without restoration of firearms, based on the opposition that was expressed by the DA without the firearm. So you've received a unanimous vote. We'll make that recommendation on your behalf to the governor. Thank you, sir.
Thank you.
So all of you who voted no in the poll were wrong, mostly. I think they found a good middle ground there. Give the guy his pardon, let him move on with his life, but not let him have a firearm. Although, now having said that, maybe not. I'm pretty 2A absolutist, so yeah, maybe he should have his firearm too. Maybe it's not a good middle ground. For a lot of people, it'll be a good middle ground. The more I think about it, for me, maybe not so much. But that's just me. We can all have different opinions. That's what we do here at TCF. Let's go to Judge Boyd.
I think the first and most informative is very
Okay.
file is.
Honorable Your Highness, Your Honor.
So awesome.
Stephanie, I really need my brother. I will be compliant.
No, just 1 second. They're going to give me an update.
Oh.
Yes.
Judge, all of the evaluations have been completed on Mr. Payne. Unfortunately, at this time, we don't have a solid placement for him. The behavioral health person, director, she was here a little bit earlier, and she indicates that at this point, they are recommending that he just go back with his brother. And once he is back with his brother, they will have a mental health behavioral specialist go to his home and do the treatment there. Immediately upon release, they will have all of the services available to him.
All right. So stay
Yes, Judge.
with Mr. Payne. The whole issue has been that he'll be released. He goes with his brother. He disappears. and then we're back here. So we've been trying for a while to get something stable for him. So they're saying that he can be placed back with his brother. My understanding, the brother wants him placed back with him. Yes. And that they will actually do services at his home. So do you have any objections to his being released with that being the plan?
No, Judge, the state does not.
All right, so that's what we'll do then.
Okay, Judge.
So you'll be released. You're probably going to be released at midnight. I have no control over when you're released. I'm not in charge of the jail.
I understand, Mr.
All right, so make sure you call your brother. I think you can still do collect calls.
Yes, ma'am.
All right, so call your brother and let him know that you're being released, and let your brother know that someone is going to be coming to his home so that they can make sure that you're on your medications and abiding by everything.
Yes, ma'am. I will do right, Stephanie.
Okay.
Last time when I left, I wasn't able to do chores because I wasn't able to walk, but I'm regaining my strength. I tell you, I regain my strength every day. I'm getting stronger.
All right,
I'm able to walk now.
okay, but here, that's a good thing, but here's the main thing. You need to take care of your mental health, all right?
Yes, ma'am.
So the caseworker is going to come out. If there's something with your medications and it has side effects where you don't feel good with it,
Yes,
you
ma'am.
need to let your doctor know and let the case manager know.
Yes, ma'am. Well, Stephanie,
Don't disappear on
I
us.
promise I won't. Y'all, I don't really behind it. Y'all definitely would.
All right, thank you so much.
Well, thank you, Stephanie, so much.
Oh, you're welcome. And
Bless life.
well, thank you. I appreciate that. Vashon.
Bailey, you're correct. We have seen him before, and I specifically remember him not just because of his voice, but because he calls her Stephanie, and she lets him, which is very off character for her. So that's how I remember him. Let's stay in Texas, but let's go say good morning to Judge Stevens now.
Jefferson County, Texas, you committed the first-degree felony of murder by striking the victim about the head and body with a bat. Do you understand what you were charged with here?
Yes.
If convicted of a first-degree felony, you face a term of life in prison or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment is applicable for a first-degree felony of murder? An agreement has been reached where you would be pleading guilty, found guilty, sentenced to 40 years in prison with credit for time served as allowed by law. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection,
Without
stage
obje-
one.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it.
Yes.
You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
We have to say it waived, Your Honor.
I'm going to follow this agreement if nothing further to add by anybody. I'm going to find that Mr. White, you pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of being guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty of this first-degree felony of murder. And following this agreement, you are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 40 years. And the judgment shall reflect an affirmative finding on the judgment that a deadly weapon, namely a bat, was used in the commission of this offense, and I'm looking, so, so it's clear it's a baseball bat. That was used. Okay. All right. Anything else?
No.
Mayor. That is all. Thank you. Yeah.
Okay, I'll do it on the sixth and try it now.
Okay.
I don't see Mr. Kelly or Mr. Kimler. Those are two that I know have pleas already ready.
We got Ray Savant is.
That's Kimler.
Where you going?
He might be back now.
Mr. Walker, on your matter, are y'all ready on something?
Judge, I'm Garcia.
Where is it?
This is Garcia. Trying to get that issue with him, Philip Yellis, that'd be up to you this morning.
Okay.
Good rights to the computer paperwork.
Sorry to hear that. Well, he hasn't
I had a couple of things.
shoot off a rocket or something, the way he manipulates the computer. Could start a war.
We should go, but I didn't have both of them just finished up this morning.
Okay, let me know.
Thank you so much.
Yeah.
He's.
All right, well, there's an obvious pause in the action there. Let's go back to Judge Boyd.
Okay, thank you. I'd like to confer with my attorney as well, please.
All right, thank you. Just give us a moment. Terrell Allen.
How are you doing?
Oh, I'm doing okay. How are you doing?
I'm alive.
Oh, yeah. Are you all ready to proceed? Or? No problem. So y'all are proceeding on the motion to revoke?
Yes, Judge.
All right, the court is calling 2015 CR 3927 State versus Terrell Allen. Can I have parties announce?
Duffy Pitlock for the state of Texas.
Brad Thornton for Mr. Allen.
And are you Mr. Allen?
Yeah.
All right. Are you the same Mr. Allen who was placed on community supervision in 2015 CR 3927 for the offense of burglary of a habitation on March 19, 2019 for a period of 3 years? Is that you?
Yeah, yes, ma'am. Yes, Your Honor.
All right, state.
Judge, we also have.
Mountcastle, what are you doing? It's Mountcastle.
Okay, yes.
There's another motion to revoke.
Oh, there's a second motion?
No, there's a second case. It's a DWI.
Oh, I have it. Yeah. And the court is also calling 2019 CR 10147W. Did you review the motion to revoke community supervision in that case as well?
Yes, Your Honor.
Are you the same Terrell Allen who was placed on community supervision in 2019 CR 10147W for the offense of driving while intoxicated third or more on October 11, 2019 for a term of 8 years? Is that you?
Yes, Your Honor.
All right. And Excuse me, could I get a file stamp for motion to revoke? And state, are you proceeding on the same allegations in each motion?
Yes, Judge. The state intends on proceeding on one, waiving and abandoning, if you would, when the state can make that announcement.
All right, you may proceed.
So,
Oh, you're welcome, Mr. Payne.
for cause number 2015 CR 3927, the state will proceed on violation of condition number 2, but the state will waive and abandon the other violations alleged.
Any objections to the waivers?
No, Your Honor.
And then in cause number 2019 CR 10147W, the state will proceed on violation of condition number 2 and waive and abandon the remaining violations, Your Honor.
Any objection?
No, Your Honor.
All right, and state if you'll read the violation into the record, please.
Yes, violation number 2 for both cause numbers, on or about the 24th day of February 2022 in Bexar County, Texas, the defendant, Terrell Allen, defendant there failed to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that violation in each of the cause numbers, true or not true?
True, Your Honor.
Did you understand by pleading true to violation of condition number 2 and cause number 2015 CR 3927, the court could find it true, grant the motion and sentence you up to 3 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. And cause number 2019 CR 10147W, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion and sentence you up to 8 years in the prison?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 8?
Condition number 2.
I'm sorry, condition number 2. Knowing that, do you still wish to proceed with your plea of true to violation of condition number 2? All right, then the court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
It is different recommendations for the 2 cause numbers. For cause number 2015 CR 3927, the state is recommending termination unsuccessful, but defendant has already been sentenced on that one. The recommendation for cause number 2019 CR 10147W, the state is recommending continued probation, but to complete state ISF cognitive track followed by ISP.
All right, so are you saying that he's already been sentenced in cause number 2015 CR 3927?
The state does see that this is the second MTR and defendant was adjudicated from deferred.
Okay.
That's what we're under the impression of.
Yes, no, he's on regular probation or community supervision. And so his maximum sentence is 3 years in that cause number. So probation?
Judge, on that cause number, that case expired March 18th of 2022.
Oh.
The court is aware of that.
All right, so and cause number 2015 CR 3927, the court is finding it true. The court will terminate you unsatisfactorily. And just one moment. All right. So then let's move on to the 2019 CR 10147W. State you're requesting ISF?
Yes, Judge. Cognitive track followed by ISP.
All right. Defense?
Your Honor, Mr. Allen, back in 2022, that was the day where there was an extremely bad snowstorm.
that occurred. And so they called him in to do a test, and he expressed that he didn't feel like he could do it safely that day and wanted to do it a different day. And so he made the decision not to do that. My client, all of the evaluations, we looked at it with probation, has never been evaluated for mental health issues. Yet in dealing with him and talking to his family, he definitely has severe issues. He's been diagnosed, my understanding from dealing with his family, with bipolar depression, as well as what I can see in my interactions with him is that very high levels of ADHD, being able to focus. And so what happened on that day was he was extremely worried, didn't know what to do, panic, couldn't deal with all the problems going on in his life, and decided to freeze and not know how to deal with that. And he hasn't had any issues since then. We think that the proper thing to deal with in the situation is to address those mental health issues now, and that he would be successful in the remaining terms of his probation, and that's what the freeze up was. It wasn't an issue of him using or being dirty. It was him legitimately being afraid because of the conditions on that particular day in terms of being icy. And so we think that this is an appropriate way to remedy both of those situations, is to continue letting him be successful, but also with a cognitive track addressing the issues.
Thank you, may be excused.
Thank you, Judge.
Yes. Yes.
On the icy day, I have two kids, right? Of course, the kids have a mom. Mom was in middle school, while mom was at the hospital. I only had me. It was me, the two kids, right? And of course, everyone seen Save the Last Dance with Julia Roberts, or yes. Okay, yeah. I can't drive, you know. I didn't want to take my kids to you can't take your kids anywhere, can you? No, so I mean I was arguing with the probation officer. I was like, can I please go tomorrow? She's like, no, Mr. Allen, I have to go.
Okay, so here's the thing. You've been missing since 2019.
For this day.
So, but here's the thing. 2019, do the math. How many years have expired since 2019 and you still haven't come in? The only time you came in was because you were arrested.
22.
Right, Your Honor. And we can present testimony on this, Your Honor. I've talked to his family, interviewed them.
No, I'm just trying to let him know
Right.
that what he's given me are excuses.
Absolutely.
And these are life. This is life, right? Everybody has different things they have to do in life, right? Now you have some people who say, oh, I'm not going to go to the store today. I'm not going to do this, but there are no real consequences for that. I mean, you don't have something to eat that day. But the consequences are you could potentially go to prison. So since from 2019 to now, have you gone to the grocery store?
Yes, sure.
All right, so you found a way to do that, but you didn't find a way to contact your probation officer and come in. Since 2019 to now, have you taken your children to school? You haven't taken them to school, so that means somebody else was taking them to school, so you could have come in. So don't come to me with excuses because you haven't done anything since 2019. You understand? Probation, what are you requesting?
Judge, the recommendation on date item.
I mean, he hasn't been around since 2019.
We're under the impression it was 2022 when he failed.
All right, so that's still not good because that's 3 years.
He was on the very last end of drug court. In fact, he was waiting for the certificate to graduate from the drug court.
No, and see, that's the other thing with drug court. I know they give people chances, and I know from drug court, and you correct me if I'm wrong, when you don't show up for something for drug court, they don't immediately put you out of the program. Yeah.
Your Honor, and
But they can't help you if they don't see you.
I appreciate you for recommending me to drug court, because that helped me out in my adult life, my full life period, discover a bunch of things. I didn't realize I had a problem. I always thought I don't have, I just didn't want to stop, And
No, I told you had a problem. That's why I sent you to drug court.
I appreciate that, Your Honor. It did help me out tremendously. It's like, I always thought I was Superman. It's like, how many times have you heard, I'm pretty sure I get this a bunch, right? It's like, hey man, you sound white. I'm like, I speak English.
No, I don't get people saying I sound white. If they say I sound white, then that's their prejudice that's coming out. Because what does that mean to sound white? What are you trying to say?
I get it all the time, Your Honor, I'm sorry.
He's talking about himself, Your Honor.
No, okay, so he needs to sign the trial court certification. He hasn't signed that. Oh. And probation, did he pay the $57 restitution to SAPD?
Yes, Judge.
Okay. All right, state.
Yes, Judge.
All right, the court is going to grant the motion. Do y'all want to speak to years? His minimum is 8 years.
Judge, that is the full range. The state has no comment on the range.
All right, thank you. Maybe excuse. Yes,
Have you be permitted to present some brief testimony?
sure.
Okay, I'd like to call Pamela Williams.
Helen?
Pamela Williams.
Hello. Hi. Hi. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Pamela Williams,
All right, defense, you may proceed.
How are you related to Mr. Allen?
my grandson.
And you been part of his life the past 10 years.
Yes.
And so when he first was placed on probation and then did not go in probation, what type of things did you see in terms of what was going on in his life and his ability to deal with problems?
Well, Terrell has been having, we've been telling him Terrell has been having mental problems for a while. He don't deal with things good, depression, bipolar episodes, different things like that. We've been trying to get him to deal with. I think I spoke to you and told you that he just needs some help, you know. As far as I know, I've been trying to help him. He says he's gonna do one thing and then, you know, he bounces back from another. So we've been trying to help Terrell get this thing situated. But I think Terrell needs some help. I'm his grandmother. If I thought I'm this type of grandmother, if I thought he was a menace to society, I'd tell y'all, do what you gotta do. But Terrell needs some help, mental help, Judge.
Mhm.
He really does. And sometimes they hide things from me. I'm grandma.
Mhm.
But I've noticed things, you know, he's been through really bad depression. But I think he just needs some mental help. And
let me ask you, there's a time where he was making poor decisions with the
Mhm.
burglary and the DWI.
Mhm.
Have you seen changes in him where he's staying out of trouble and not hanging out with the bad friends?
he's changed. He's changed. He's so changed. He stayed locked up in a room all day. And so we were even afraid that he was gonna, you know, do something. He's changed. He's really changed, but he just needs some mental help.
Have you seen the alcohol or the drug issues that were going on?
No. He doesn't have any.
And you saw that before,
Sure, yeah, I saw it before.
and you haven't seen that now.
No, because I told him when you're a child, you behave as a child, but become a man, you gotta put away some things. So I haven't seen those things. And like I say, he really does, Your Honor. He has some problems, some issues that are not, I say, a menace to society. I think he just needs some help.
Mhm.
And I tell them, I'm the type of grandmother
that I tell them the truth about things. Like I'm telling you the truth. I really think he needs some mental health. Terrell is not, I guess you hear this all the time. Terrell is not a bad boy. He's not. And I just think he needs some help. And we asked, that's just.
And if whatever the judge decides to do, whether it puts him in prison and he gets out or gives him the help, you don't see the problems in him that were going on back with it. So you're not concerned about alcohol or drug abuse?
No, not at all.
Or the criminal behavior?
Oh, no, not at all.
Okay, I pass it.
Not at all.
All right, any questions?
No questions from the state now.
All right, so this is what I want you to understand.
Yes, ma'am.
I appreciate your coming down and telling me things about him,
Yes, ma'am.
but I don't want you to go away thinking that help wasn't offered to him, because the felony drug court where I sent him, they have a dual diagnosis problem. So they check for mental health issues. They will give them mental health help. They will give them help with their drug addictions. They do all of that. It is a global wraparound service for people who are in that program. And that's why I sent him there. And felony drug court is different. And these treatment courts are different from different courts, right? From your regular courts, I should say. Now, of course, based upon my knowledge, I will use what I've learned from the different treatment courts in this court sometimes. You know, I see if somebody has mental health issues or if they have a drug issue, then I try to get them help for that.
Right.
And I always tell people, if you have a drug issue, mental health issue, and you let me know about it and I don't give you anything to help with that, then that's my fault. But if you tell me, I'm fine, there's nothing, right? So with regards to your grandson, I knew the issues he had because he was on probation in this court for 2 cases. And that's why I sent him to felony drug court instead of revoking him at that time. Now, felony drug court, when people miss reporting and they go missing, because sometimes people will, what they say, fall off the wagon, go back to their old ways. They will do their best to work with them and try to find them. They have probation officers who will go out to wherever their old haunts were. They will walk, they will go on corners, everything to try to find them, to get them back in compliance before they issue a motion to revoke. So when these treatment courts do a motion to revoke, they've tried everything. There's nothing else for them to do. So I want you to understand that he was offered the help and he was in felony drug court. And he didn't follow through.
Yeah, speak.
Sure.
Well, I was thinking sometimes they don't really, you say you need help. Everybody say they need help. But sometimes it takes a while for them to realize that they really need help. I mean, really, seriously.
Yeah.
For a long time, he didn't think he needed any help.
Oh, no, I understand. That is why.
Everybody was saying he needed help.
No. That is why when he picked up a new charge, because he was previously here for a different felony case. And then he ends up picking up a DWI. That's why I didn't revoke him, because I knew he needed help.
Right.
And that's why he went to felony drug court. And felony drug court is intensive. They have something they have to do every single day. So, you know, you can only offer somebody so much help. And then when they don't follow through, they don't follow through.
Like I said, I think Terrell didn't know.
Okay.
I'm serious, because we've been telling him for years that you need help.
Yeah.
But I think he was in the mindset that I don't really think I need help.
Okay.
You know, and I know you said you probably send him different places and you saw it, I saw it.
Yeah.
His parents saw it, but I think he just finally began to see it. He really needs help.
Okay.
He really needs help. And I'm asking you, he really needs help.
All right.
Well, I
appreciate you for coming down and telling me things about your grandson.
Okay.
All right. Thank you.
Thank you.
You're welcome. Do you have any other witnesses?
No, the witnesses, no.
All right. If you'll come forward. All right. So, Mr. Allen, you know that the court has given you a chance, more than one chance.
You helped me out a lot.
Yeah. You were on probation. Then you picked up a new felony. Then I sent you to felony drug court. And felony drug court, they have a dual diagnosis program to work with you with mental health, to work with you with drug issues. Felony drug court, when you, and anything I'm saying, if it's incorrect, let me know.
I don't think my grandmother was.
Yeah. No. I'm not talking about, I'm just,
Yeah, no.
what I'm
no.
saying now, if what I'm saying is incorrect, let me know. Felony drug court, when you get out of compliance and you go missing, they send people out to try to find you, to bring you back in.
I felt love Judge drug court.
Okay.
Judge Glenn for mayor, you know, I love Judge Glenn.
All right. So, yeah. Okay. All right. The court is going to grant the motion. The court is going to order therapeutic community, give you credit for any time served. How much time are you asking for, counsel?
With credit for time served,
Yeah, you get credit for time served.
we haven't. I haven't
So the
figured
range
that
of punishment for him is anywhere from 2 to 8 years. How much are you asking for?
Oh, in terms of being sentenced, okay,
Mhm.
we're asking for 2, and let me tell you why we're asking for that, Your Honor, is because you heard from the testimony that, you know, he's turned his life around, he just has an extremely poor decision-making process. And we think the sooner he gets back in society, the sooner he can build off of where he is now, which is understanding of what's going on. And I think if the court chooses to punish him with that, which we would understand and appreciate, the lowest number to allow him to jump back into society, see his kids, and build off of the good place he is in his life right now would be the best thing for him. So we're asking for 2 years. Your Honor.
All right. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I request the therapeutic community for you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
We just now talked about it, Your Honor. I can go over it.
All right, because this is because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you when you're released from prison. If you need anything and I'm here and you need help, just let me know.
May I ask how much back time I have?
Sure. Huh?
May I ask?
We'll find out. I'll tell you.
All right, is the person here on Travis Smith? Lacey Strunk?
Yes. Yes.
All right.
No, and so just ready to.
Hi, what is happening with this case?
Well, Your Honor, I filed a motion to set a bond on
Okay.
Ms. Strunk here.
Are you ready to proceed on the motion to set bond?
Yes, Your Honor, the state does have a recommendation.
All right. And have you all reached a recommendation or no?
We have not, Your Honor.
All right. Court is calling 2025 CR 0000308, State versus Lacey Strunk. Can I have parties announced?
Ashley Jones for the state.
Nelson Skinner for the defense, Your Honor.
And are you Miss Strunk?
I'm Miss Burns now, but yes, Your Honor.
Oh, I'm sorry.
I'm Miss Burns now, but it was previous.
All right. It says Lacey Burns Strunk. Is that you?
Yes.
All right. Defense, you filed a motion requesting a bond?
Yes, Your Honor.
All right. And state you're ready to proceed?
Yes, Your Honor.
All right. Defense, do you have any witnesses?
I do. I would like to call Diane England. And
All right, Diane Anglin, if you'll come forward, please.
Over here.
All right, and
Mayberry.
just one at a time.
Oh.
And to the clerk?
Yes.
I don't have the thing on Strong.
Strong.
Yes, the docket statement. All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Smooth.
You can lower your hand, state your name for the record.
Diane.
All right, defense, you may proceed.
Ms. England, you know Lacey Burns Strunk, don't you?
Yes, sir.
How's that?
She's my daughter.
She's your daughter? Where was she brought up at?
In San Antonio.
Here in San Antonio?
Yes.
Is that where you were brought up at?
Yes, actually in Adkins, right outside San Antonio.
Adkins? That's still in Bear County. isn't it?
Yes, sir.
And you have family members who were here before you? Your parents? Or your grandparents? Were they living here in Bear County as well?
Yes, sir. All of my family's from here.
For how many generations back have y'all?
Oh, since my great grandfather came from Germany, I guess.
Has Lacey Strunk ever, she's been residing here all her life?
Yes, sir.
Has she ever indicated a desire to leave Bear County?
Never.
Has she's never threatened to move or
No,
even
sir.
consider it?
No, sir.
Okay.
All right, let's go off the record for a moment. So in the defense motion, he says that she's accused of contacting the complainant about returning the children's coats for cooling weather when he refused to communicate through a third party. Is that what this case is about?
It is.
Yes, sir.
All right, so here's the thing. Step back for a moment. Oh, no, just have a seat.
Oh.
Also, are we proceeding on a violation of protective order for somebody texting somebody to say, please return the children's coats because the weather's getting cold?
That's what their motion amounts to.
Well, no. I mean, I just want to know, is that the allegations?
Yeah.
Yes, so there was a protective order that was agreed to in August, late August of 2022. The defendant then called the complainant several times, and then the last violation is the text about the coats. I will say that this case is just newly indicted, so I have not had a chance to review or talk with the complainant yet, and so we're just
All right, so is there any objection to a PR bond with well, I really can't do a PR bond legally.
and that's the issue.
I was going to ask you to do that, Your Honor.
Legally,
Illegally.
So
Legal, oh, no. I will tell you this, illegally, I'm not allowed to do that, but if I could do it, I would grant your client a PR bond. This appears to be a bunch of nonsense to the court.
I think I have maybe $100 cash, Your Honor. Could we do $100 cash bond?
No, I mean, I can't accept cash here. What are we doing? No.
Take credit cards?
So, no. So what are you asking for a bond?
Your Honor, the state's asking for a $3,500 bond and a no contact order.
All right, so come forward, please. We're back on the record. State, do you have any concerns for the complainant's safety?
At this time, Your Honor, the state has not been able to make contact with the complainant, and so I can't say from the last conversation we had, yes, he was concerned for his safety. That was, however, back in February of 2023.
All right, so can somebody tell me, what is the basis for the protective order? What's the underlying facts for the protective order, allegedly?
Allegedly, there were a couple of assaults where this defendant is alleged to have committed against the complainant, as well as, I'm not sure the relation of the second victim, but both of those cases were dismissed. However, it seems like there was a tumultuous divorce, and the agreed protective order was the result of those cases.
And then I have a previous, in the defense's motion, he says there was a previous jury trial.
That was out of a different county for a violation of a protective order.
Against this complainant. All right, and it was a not guilty verdict.
It was a not guilty verdict.
All right, so this is what the court is going to do. I'm going to set your bond at $3,500. I'm going to place you on GPS. They'll do it at the jail. I'll ask that the fees be waived. You are not to have contact with the complainant. Do you understand? You're not to text him or her. You're not to call them. No contact whatsoever. And with regards to the children's court, this sounds silly to the court, but guess what? I have no control over that, right? So you need to make sure it's done through a third party. If he doesn't pick up with the third party, I'm sorry, you are going to have to buy extra coats for the children. Do you understand? I don't know why adults can't be adults when it's concerning children, but sometimes they can't. That's when the courts step in. So I'm setting your bond at $3,500. If legally I could give you a PR bond, I would, but I can't. And I don't know the entirety of the facts of this case. I'm just going by what the attorneys are telling me. So that's why I'm setting the bond at $3,500. I don't know about the previous cases involving this complainant, but it's as much for your protection as it is for the complainant, so no one will accuse you of anything. Now, with regards to the GPS, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, if you could state your name for the record.
Lucy Burns.
All right, do you have employment?
Yes, sir.
All right, what is your work schedule?
7 to 30.
All right, so this is what I'm going to do with GPS. With regards to the GPS, I'm going to do a tracking. They're going to put in the motion the address and the locations where you're not allowed to be. If you violate the GPS, what's going to end up happening is they're going to come back to me with the violation of the GPS.
Can I state something?
Sure.
When this incident first happened and the texting, he turned me in on that then. And they put me on a GPS and I wore it for 6 months and I have not had any contact with it in over 3 years.
So are you still on GPS?
No.
She has had no contact with him for 3 years, and for the 6 months she was on that GPS device previously. And the problem with that, from her perspective, is if the court orders a GPS, the last time the court ordered a GPS on her, she had to sit in jail for 6 days before they got.
No, they don't have 6 days here. They have a GPS at the jail. They'll put it on her. Here's the thing, I'm trying to save you money. If, however, you want to pay for it for yourself, you can pay for it for yourself. But if you want the free GPS, it'll have to be done at the jail, and they'll have it done. If we're able to get you back at the jail quickly, they'll have it done at the latest tomorrow.
And you had to go to work, what time tomorrow?
7:30.
At 7:30 in the morning.
All right.
Is that right? 7:30 in the morning?
Yes.
If nobody has any objection, I'll call the jail to see if they can make sure that she has the GPS placed on her tonight.
No objection.
Thank you, Your Honor. I appreciate that.
All right, so the bond is going to be set at $3,500. And if you all can put in the motion, the locations and the names of the people she's not to have any contact with. So I'm telling you this, and I want you to hear me clearly. You're not to call this person, text this person, or anything. If you do any of that, regardless, it's a violation of a protective order. Do you understand?
Yes,
And it's a violation of my order. And then you're going to come back here because somebody's going to give me a pretrial violation and I'm going to sign it if it appears to be in order. Do you understand?
Yes.
All right. I'll write it on here. All right, that will be all. And Ms. Ferguson, we need a date for this, a 30-day reset, please.
We just said
Hang on a second. August 4th.
Here's the thing. You can do a jury trial, you can do a bench trial. If you do a bench trial and come to me, what's going to end up happening is if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. And let me explain something to you. You can come to me. I'm going to keep an open mind. But what I can tell you, if there's a protective order in place that says you're not to have contact with him, then you're not to have contact with him. It doesn't matter what it is. You understand? So you can ask your attorney if it's best for you to have a jury trial or a bench trial. If the state proves their case beyond a reasonable doubt, so for a violation of protective order, if they prove to me that there was a protective order in place and it's a legal protective order, right? And that you violated, I'm going to follow the law. You understand?
Yes, Your Honor.
You can't do a bench trial nullification with the court. You understand? And your attorney will explain that to you. So you want a jury trial?
Yes.
All right, Ms. Ferguson, if you all confer and get a jury trial date, please.
Yes, sir.
They're gonna take you and process you in and process you out as fast as possible. Have a question?
Okay, let's go back to Jefferson County and spend a few minutes in Fashion Court.
Allegedly at a house. The fact that you're on bond and using methamphetamine. I'm going to find that you violated your bond condition. Raise your bond at this time to $150,000. I will appoint an attorney. Also, a condition of that bond, if you make it, is that you will be required to wear a drug patch at all times. You can go. Do you understand?
Yes.
All right, go back with the bailiff. Thank you for your help.
Yes. He's asking if he can tell his mom that's outside what's going on.
The bailiff will tell, if you'll tell him that.
Yes.
Mr. Burbank, on Ariana Evans,
That's Mr. Kimler's, Your Honor.
what did I say?
You said Burbank.
Oh, looking at two different things. Mr. Kimler on Ariana Evans. Ms. Evans tested negative. What's the announcement?
She wants to stay on probation, Your Honor.
That's not an announcement. We
Well,
have
I
an
think it's
MTRP.
clear.
Are you gonna
Clear.
plea on it? Are you gonna?
The reason I say that is she refused the state's offer for an agreed recommendation of 60 days.
Okay. So,
They plead her on the, and then we can go through administrative violations and she can enter pleas.
I'll go through all the violations and she can enter pleas if true or not true to those. Give me just a second. All right, ma'am, you are Ariana Evans?
Yes, ma'am.
Ms. Evans, best you can, or raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And Mr. Kimler, will she waive the formal reading of the motion?
So, Your Honor, I was just informed there that count one is incorrect. It's not, should not be failure to report. It should read failure to maintain employment. State moving to that? I am. No objection.
Okay. All right, so I have in cause number 22-41163, a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 25th of 2023 for the offense of obstruction or retaliation, a third-degree felony.
Your Honor, it was at that time, it was reduced to a Class A misdemeanor.
Okay,
So she's on misdemeanor probation.
so do you want to make a motion to amend that motion's
I see that
a
now.
mess?
It should read terroristic threat, Your Honor. Class A.
It's not even obstruction, it's terroristic threat.
Right. Class A, right? Yes. Yeah. No objection, Your Honor.
Hold on. I did additional version, but I'm printing it because. All right, so it should read the offense of terroristic threat, a Class A misdemeanor.
Yes, Your Honor.
Thank you. Terroristic.
Yep. Would it be against a public servant? It is, I mean, specifically it's terroristic threat against public servant, but
Against.
that's what makes it an A, I think. Yeah, because you're right, regular is a B.
Okay, so, and then state is abandoning count one, or
We amended, Your Honor. We moved to,
you want to amend count one?
yes, Your Honor. For, failed to maintain employment in violation of, to make sure the count's correct. Count number 4 is, sorry, it should read, the said Ariana Evans failed to maintain employment in violation of condition 4.
Any objection to that amendment?
No, Your Honor.
Okay. All right, so Ms. Evans, I have a motion to revoke your unadjudicated probation. It alleges that, first of all, you were placed on probation September 25th of 2023 for the Class A misdemeanor offense of terroristic threat against a public servant, and that was a 2-year deferred probation. Is that correct?
Yes, ma'am.
And count 1 alleges that you failed to maintain employment and provide verification of that to the probation department. And is that true or not true?
I had a job. I let them know I had a job.
Okay, so that's not true. Is your plea correct? Answer out loud.
Yes, ma'am.
Count 2 alleges that you failed to remain in Jefferson County as ordered and that you were in Louisiana on April 20th of 2025 without permission. And is that true or not true?
Yes, ma'am.
True or not true?
It's true.
Count 3 alleges that you failed to pay your court-assessed fees as directed and that as of April 21st of 2025, you were $2,394 behind. And is that true or not true?
Yes, ma'am. It's true.
Count 4 alleges that you provided a urine sample April 25th, 2025 that tested positive for alcohol. And is that true or not true?
Yes, ma'am. That's true.
And then count 5 alleges that you failed to enter and successfully complete the JCDI program. Is that true or not true?
Yes, ma'am. It's true.
Did you enter your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But what I'm going to do is reset your case for a sentencing hearing. And I'll ask probation to do an updated report. We'll come back. I'll get that report, see what all's been going on while you're on probation, and then I'll make a decision on that day what to do. If there's anything that you think is important for me to know, you can get that information to both Mr. Kimler and your probation officer, and then they'll present it to me either through that report or on your behalf when we come back to court. Okay?
Okay, yes, ma'am.
All right, you can. You're free to go. Make sure you stay in touch with probation and do what you're supposed to do. All right.
All right, let's stay in the building, but go back to Judge Stevens for a few minutes.
That's
Give up your right complement.
this off the top.
Lock right there.
Yes.
And press right here. Yeah. No front judge.
How many cases? Was it 2 or 3? So far, 4.
Well, they're dismissing one.
It's 4 cases?
They're dismissing one.
I'm asking, are there 4 or 5?
Three. Well, 4, but they're dismissing.
Okay. Okay.
The state,
And
Yeah,
we got
yes.
3 in the queue, plea queue, correct?
Yes, sir.
All right, we got 598. 1355,
Yes.
1356,
No, this is true.
and I presume then 1357 will be the one to be dismissed.
The state jail.
1357, yes, sir.
You are Ray Edwards Savat,
Yes, sir.
present. Mr. Kimler, your attorney and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments here? Can we proceed in summary?
He does, we may, Your Honor.
We just going on the first paragraphs in each of these?
Yes.
Looks like we got a 3rd-degree felony and then 2 second-degree felonies.
Correct, Your Honor.
All right. In 24 CR 598, in summary, sir, this indictment alleges that on or about February 15th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with there?
Yes, sir.
Third-degree felony means that you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you'd be pleading guilty, sentenced to 5 years in prison to run concurrently with the other cases. Is that your understanding of the agreement? And 1 case will be dismissed.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to hold that one in suspense. Go to the next two, 1355 and 1356. And does the defendant waive formal readings of these two indictments? Can we proceed in summary?
He does when they.
In summary, each of these, and can we take them up together?
No objection.
Each of these similarly allege that on March 6, 2024, in 1355, and on or about February 20th, 2024, in 1356, in Jefferson County, Texas, you are charged on those different dates for illegal possession of a controlled substance, namely methamphetamine. Second-degree felonies in each case. Do you understand what you're charged with in those two cases?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000 in each case. Do you understand?
Yes, sir.
Agreements have been reached where you would be pleading guilty in these three cases. Found guilty, sentenced to 5 years in prison to run concurrently with each other. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead then in each of these cases? The third-degree felony of evading arrest or detention with a motor vehicle in 24 CR 598.
Guilty.
And in to 24 1355 and 1356, the second-degree felonies of illegal possession of controlled substance. Are you formally entering pleas of guilty in each of these cases?
Yes, sir.
Are you pleading guilty in each case voluntarily,
Yes, sir.
knowingly, intelligently, and because you are guilty of what the indictments allege in each of these cases?
Yes, sir.
In each of these cases, I show you what's marked as State's Exhibit 1. Did you sign those documents
Yes, sir.
voluntarily, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 in each of these cases is tendered into evidence without objection admitted. State's Exhibit 1 in each case similarly states that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with your attorney in each of these cases. So help you God, it states.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes for each case without objection.
No objection.
Pre-sentence reports are waived.
So waived.
I'm going to follow these agreements if nothing further and find in each of these cases, Mr. Sevat, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each of these cases from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. In each of these cases, you are hereby sentenced in accordance with these agreements to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years imprisonment. Each of these cases shall run concurrently. Do you understand what has happened today,
Yes,
sir?
We got the dismissal on the bank.
Yes, sir. Absolutely. Stand by.
The state jail. Yeah, so everything's wrapped up.
And 24 CR 1357 is before the court. There's a motion to dismiss in that case as part of the agreement. In all of these 4 cases pending, I've signed it. That case is dismissed. Do you understand what has happened today, sir? Oh,
Thank you.
do better. Okay.
Judgments are yelling this ready.
Okay, ladies and gentlemen. Da 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 dungeon court.
Most that can happen. There is a minimum. Most charges don't have a minimum. This one has a minimum. So if you're found guilty, I can't give you less than 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum penalty. Do you understand that charge and possible penalties?
Yes, sir.
The state's saying that they've got both, and this is a little confusing to me, so I don't understand. Both the box check for a breath test and a urine test, which that's unusual. Usually you get one or the other, are checked, so I don't know what happened. If it is a urine test, it'll take a while to get the results because those go to a lab for testing, and I don't have any results in the file at this point. The state's also alleging you were driving 54 miles an hour in a 35-mile-an-hour zone. That's a non-jailable speeding offense. Maximum penalty is $150 fine. And that you had a headlight out. That's minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead?
No contest.
If you enter a no contest plea, you're giving up your right to have an attorney to make the state prove this charge beyond a reasonable doubt. I don't have the results back, but on the urine, or I'm looking at the report, it looks like maybe the officer saying you refused to take urine. So anyway, if you enter a guilty plea, you're admitting that these charges are true, and you're waiving the right to have a trial and have a lawyer. I'm sorry, if you enter a no contest plea, what you're saying then is, I'm not putting up a fight on these charges, I'm not admitting I'm guilty, but I'm not denying it, and I'm going to agree that I can be found guilty without a trial and a lawyer. If the court thinks the evidence the state says it has is enough for conviction. So it usually 99 times out of 100 is going to result in a guilty finding. Is that what you want to do?
Yes, sir.
Okay. Well, there may be something that I didn't know that I'm going to see in the report that I'm going to have to. Okay, I've got an impaired driver report from Trooper Beam, who's the arresting officer. Okay. June 28th at 12:59, I had set up stationary positions 775, mile plus 0, monitoring speed of vehicles traveling that zone. I observed a vehicle traveling toward me, I estimated to be 55 miles an hour, activated my forward-facing radar. Had a clear signal. The vehicle speed was checked at 54 miles an hour. It dropped to 51. I also witnessed the passenger side headlight was not on. I followed the vehicle. It was a black Ford Taurus. Used the license plate number activated overhead lights. Approached the driver's side vehicle, detected an odor of burnt marijuana before I reached the driver's side window. The driver was Austin Schaefer. His speech was lethargic and slurred. I informed him of the reason for the stop, asking for ID. Mr. Schaefer said, "I'm out getting cigarettes." As I talked with him during the stop, I could detect the moderate odor of an alcoholic beverage coming from his vehicle. It also took a bit before Mr. Schaefer made eye contact with me. When finally did, it was clear that they were watery and bloodshot. Asking about his alcohol consumption, he said just 1 or 2. Asking him to step out of the vehicle, and he exited, walked in front of the patrol car. He told me he had been drinking shooters. He also told me that he had been at a bar called the Lantern in Huntington. Went through some preliminary questions, see if he could perform field sobriety tests. Said he was not taking prescription medication. He had a history of any head injuries, which he denied. 4 clues on the horizontal gaze and the nystagmus test. That's an alcohol test. 3 clues on the one-leg stand test, portable breath test. Asked him to give a sample. He said that he had smoked a blunt or 2 of marijuana. The BAC on the portable breath test was 0.36. He was transported to the post, read and shown the MV 2255 form. Was asked for breath and urine samples. He was unable to urinate. He was cooperative and respectful throughout the traffic stop. All right, you have any explanation or statement you want to make?
No, sir.
All right, based upon some alcohol and some admitted marijuana use, I'm going to, in your test, I'm going to say there's sufficient evidence for a finding of guilty that you were impaired, your ability to operate the motor vehicle was impaired. Are you employed? What do you do?
I work in Middleton at Giovanni's.
Okay. You have proof of insurance, so that's good. Does the state take any position on this Simpson?
No, Your Honor, first offense, and appears he was cooperative anyway, so we would not do mandatory minimums.
Okay. Anything further you want to say, Mr. Schaefer?
No, sir.
All right, I'll give you a $375 fine, that's the minimum fine. Or you pay the court costs. 6-month license suspension, it'll start the day of the incident, June 28th. It's going to be up on Christmas Day, December 25th. It'll be the last day of your suspension. 20 days in jail, which I'll suspend on the condition that you do the other things you're ordered to do, one of which is 5 days community service. We have a community service program here at the court. You can work any day that's Sunday at 7:30 or a holiday. You can't work on a holiday. Just come here at 7:30 and we'll get you someplace to work in the community. You have to go to a 3-day treatment program. That's mandatory. If I don't give you jail, you gotta go. There's one here in the county, but you can go to any one that's approved by the state of Ohio. There's some cheaper ones, to be honest. I think the one that's the cheapest that I've heard of is the Shell Coffee, and it's a couple $100 cheaper than the one here. So it's up to you. It is, those are inpatient first, so you gotta go stay for 72 hours. I'll set your review hearing for January the 12th of next year. So what the review hearings are, under here, we had some this morning. So check to make sure people do what they're ordered to do. So I don't want you to go to jail. You don't have to go to jail, but you can still go to jail if you don't do this stuff. And, you know, this morning, if you were here and watched, there was people that didn't show up for the review hearings. Every one of them got a warrant. So what's going to happen there is, the sheriff is not gonna go beat down their door and pull them out, but the next time they get a speeding ticket, they're not gonna get just a ticket. They're gonna go to the courthouse because they got an outstanding warrant for not coming to their review hearing.
Right.
So just do what you're supposed to do, and you won't have to go to the jail. Okay, I'll give you, since you do have a proof of insurance, and you're gonna have to maintain this, I'll give you a permit to drive during the time of your suspension for work, since you are working, to come to community service, to go to the 3-day program. Anything else emergent type driving you need to do.
Okay. No, sir.
Okay, so you'll get that from your probation officer. You're gonna meet with Mr. Major. He's gonna be your probation officer. Everything I've told you is gonna be on a piece of paper called the judgment entry. That's what she's preparing right now. I'm gonna sign it, the prosecutor's gonna sign it, they'll give you a copy. And it's filed here electronically. And for everyone listening, there's no excuse like, well, I lost my paper, so I didn't know what I was supposed to do. That's not an excuse. Because one, that record is here at the court, and you can actually access it by going to the court's website, put your name in a record search, and it'll show you what you're supposed to do, when you're supposed to do it, when you gotta come back to your hearing. So no excuses, I lost my homework. My dog ate my homework. It doesn't fly here. You're gonna go to jail if you do that, okay? It's not just for you, because we got a lot of people listening, but people still do that. They blow it off thinking, no, it's like 7th grade math homework. If I don't want to do it, I don't have to do it. And then you're going to go to jail.
Don't need that.
On your speed offense, I'll give you a $30 fine. And the headlight charge, $10 fine.
Thank you.
Any questions?
No, sir.
Okay, when you walk out the doors of the back of the courtroom, 90-degree left to the west side of the building, that counter over there is probation. Go over there, give them your name, tell them you need to check in, they'll give you your paperwork, and after you've done that, you're free to go.
Okay.
So a couple things real quick. First, for those of you who might have been looking for Ellie because she was so active during the pre-show, she has just passed out over in Beth's chair on the other side of the table here and has just been sleeping this entire stream. But for those of you who wished us a happy first gotcha day, thank you very much. He said that the dog eating the homework doesn't fly in dungeon court, but I will point out that you can be fed to the dogs there, so that's something. And I would like to direct your attention to the defendant's table of sacrifice there, and you'll notice that they've added a bottle of hand sanitizer, which I think is great because it just makes cleanup easier for blood and other bodily fluids. So I thought that was nice of them. We got a couple more minutes to go. Let's go back to court.
State's alleging you tested 12. If you're found guilty of this offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum is 3 days in treatment, $375 fine, 6-month license suspension. And that's the only charge you have. Do you understand the charge and the possible penalty?
Yes, Your Honor.
You understand your rights?
Yes, Your Honor.
How do you plead to this charge?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I work lawn care in Garrison, Kentucky.
Are you paid by the hour?
Yes, sir.
How much per hour?
12 an hour.
How many hours a week?
Usually about 30 to 35.
Okay, you're eligible for court-appointed lawyer. You'll have to fill out an affidavit that verifies your income. I'll appoint Mr. Smith. Not guilty plea is entered. He can sign a signature bond, $1,500. As long as you show up, you don't have to post the money, just come to court as ordered. you'll need fingerprinted. So put it, check the box on this bond form, or you'll have to go to the Lawrence County Jail and get fingerprinted. It's part of the bond also. Setting pretrials, the 21st or after July.
Let's see. I'm here the 21st, please, 28th.
21st is okay?
It is okay, yes, sir.
Okay, let's set it for the July 21st, will be the next hearing. Be a pretrial at 10 o'clock.
And we already have the urine results. I don't know how that happened, but.
Also, he took a breath. This is Cameron Carroll.
Yes, I've got, this one is from May 24th.
Oh, has he got another case?
Oh, he sure does. He's got two.
Let's pull up his name, see if there's another-
The other one is 25/16/80.
Okay, and Mr. Smith is the attorney on that.
Thought that name sounded familiar, Judge. I was trying to figure it out.
It's set July 21st.
What was that case number? Because that's the same case number.
Oh, that's this case.
All right, folks, I'm out. I've got to go, as you know. Be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Thank you for everything today. Keep your eye on the channel. There are 3 long-form videos that are scheduled to go during the day, so they'll be popping up for you. But again, see you tomorrow. Take care. God bless.